And we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Big mistake. Cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. So we ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We are a peaceful people, struggle is we struggle, and we don't look for trouble, just ask around. But when outside faces from foreign places talk about taking over, we ain't backing down. We ain't giving up no mountains, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. This land is all I know. We gonna make it somehow. We will bend like a bow and never break. Our fathers came here and they lived and died here, and we ain't moving nowhere. Big mistake. Cause we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we. Not one blue sake, not one rice grain, not one caress, not a blade of grass. We love the open country of the Rupununi and the Essequibo, the time when night. Though we may criticize it, this is our home, we love it, and we need to keep it. We have that right. So we ain't giving up no mountain, we ain't giving up no tree, we ain't giving up no river that belongs to we.
Honorable members, the speaker. Thank you, honorable members. Please be seated. I have been informed that the honorable member, Mr. and Leader of the Opposition, Mr. Aubrey Norton, would not be speaking. So I now call on the Honorable Attorney General and Minister of Legal Affairs, Mr. Mahabir Anil Nandlal.
Thank you very much, Mr. Speaker, for the opportunity to speak on this very important bill that is before the House. Mr. Speaker, my colleague, honorable ministers, have done a remarkable job in articulating very elaborately the important characteristics and elements of this bill, and I want to thank them for their presentation. The opposition also has expressed their robust support for the bill, and I also want to thank them for their support. Unfortunately, however, in their presentations, they have put before this House a lot of misinformation and misunderstanding of the provisions of the bill. And therefore, Mr. Speaker, I wish to take the opportunity to address some of those misinformation in my presentation. Perhaps a convenient point to begin, Mr. Speaker, is to recognize that in 1989, this Parliament enacted the Condominium Regulations and Miscellaneous Provision Act, which now is Chapter 36:22 of the laws of Guyana. That was over 33 years ago. And with mere passage of time, Mr. Speaker, that bill requires, or that law rather, requires review. But the question has been asked, why this bill? And perhaps I should interrogate that law a little to paint the picture of why this bill is necessary. So if I may invite us to reflect back to 33 years ago, 1989, we were living in a radically different world and certainly a radically different country. In 1989, Guyana was under dictatorial rule. In 1989, Guyana was a bankrupt economy. In 1989, Guyana was largely funded by a IMF financial program titled Economic Recovery Program, and we were widely regarded as a basket case. We have heard today that condominium is still a relatively new concept in the year 2022. Just backpedal a little to imagine what condominium would have been and would have meant to the ordinary Guyanese in an impoverished economy in the year 1989. The question, therefore, must be asked, why that 1989 law? And I can only find one sensible reason. We had no investments of any magnitude to speak about. We did not even have a housing ministry at that time. There were no housing drive. The economy was completely stagnated, and there was social decay. Yet in the face of that, you had a condominium law being enacted by the parliament of the country. The only rational reason I can proffer for the enactment of the law in 1989 was to bring regularity to a set of structures that were constructed decades before 1989, and the need to bring regularity to the ownership of those structures so as to give persons who were occupying those structures some form of titular ownership in relation to those structures. The Honorable Member Annette Ferguson made reference to some of them. Some of them were located and are still located in Campbellville Housing Scheme, in West Rheinveld, in East Rheinveld, in Lane Avenue, and even some at Wismar. What the Honorable Member does not know, and I say that positively, is that those structures that she apparently took political ownership of under the umbrella of the People's National Congress, and wrongfully so, were constructed by the 1957, 1961, 1961, 1964 PPP government prior to independence. That is the first important point I want to make. The Honorable Mistress Jana Jagan was the Minister of Housing at the time, and I don't wish to dispute that. A quick check of the record will confirm what I am saying. But 40 years after that, the PNC, to their credit, sought to bring this law into the Parliament and into force in order to bring regularity to the occupants of those buildings and to give them titles, therefore, because they were tenants. So they brought the law into force in 1989, and from 1989 to 1990 to 1991 to the end of 1992, when they lost government, not a single transport was issued for any of those structures. It means that they brought a law into force that was never ever used by the government that brought it into force. And that must be put on the record. The process of bringing regularity and titular ownership to the occupants of those premises commenced between 1995 to 1997 under the People's Progressive Party civic administration. And those occupants who were tenants were granted what was permissible at the time, a document called a certificate of sale that made them the titular owner of those premises. But Mr. Speaker, the law existing at the time and still now existing had some major deficiencies. And I will now highlight those deficiencies. But before I get there, I want to move us from 1989 to 2022. As I said, in 1989, we were a bankrupt country. In 2022, we are the most buoyant economy, growing at the fastest and largest growing rate on planet Earth. That is also an undisputable or indisputable fact. There is a commercial, building, accommodation, and infrastructural explosion taking place right across the length and breadth of our country. Investors are flocking our doors. Branded hotels are here in double-digit numbers. Just a few yards away from this center, to the west of this edifice, there is a huge construction ongoing that will accommodate a 350-room hotel establishment with conference room facilities and multiple restaurants and other recreational facilities. Not very far from here, there is a Best Western hotel that will be constructed. We have branded hotels such as Marriott, the Hilton, the Holiday Inn, and many others that have already begun construction in Guyana. As part of this real estate explosion, we now have international real estate corporations participating now in our economic sectors. I speak about the Canadian giant Remax and the United States real estate giant 21st Century Realty. They are here in Guyana because they see the opportunity of doing great business in our country. Mr. Speaker, it is a public secret that we have inadequate accommodation facilities in our country currently. And from all indication, the situation is likely to get dire. What we want to do as a government and as a responsible regulator of the economy is to ensure that not only do we have the facilities relevant and requisite and the foundation necessary for hotel accommodation, but we also do so in terms of having available a structure to accommodate the different styles of ownership available in the accommodating and hospitality industry. Apartment complexes, townhouses, and condominiums form part of that important matrix. And this bill, Mr. Speaker, is to put in our law the most modern legal expression available in this hemisphere of an infrastructure where condominium schemes and the construction of condominiums can flourish. So that's the first reason why this bill is before us. The second most important reason why this bill is before us is because the current law contains some patent and latent deficiencies, some of which were touched upon by my colleagues, but I will take the opportunity to elaborate upon them. Mr. Speaker, Guyana has two systems of land ownership prevailing side by side. A Roman Dutch system that produces a title called a transport, and we inherited that system from our colonial experience, starting with the Dutch, and when the English came, the English retained that element of the Dutch legal system, and today we have a Roman Dutch land ownership system that produces a title document called a transport. And that system has its own peculiar rules and regulations governing it. Side by side with that system is also in Guyana a system known as land registration. The land registration system is a modern system which we imported from Australia and New Zealand, and it's a quick and efficient system, quite modern, very strong, and that system produces a title document called a certificate of title. Unfortunately, the current condominium law of our country only speaks to the Roman Dutch system of land ownership, and it merges that system into the Condominium Act. So the certificate of sale that a condominium owner has as a title under the condominium law is regarded as a transport under the Deeds Registry Act, which is the act that governs the transport system. And for all intent and purposes, the Deeds Registry Act says that that transport, that certificate of sale, is as good as a transport. What the condominium law omits to do, however, was to make a corresponding or a set of corresponding provisions in relation to our land registration system. So you have now to apply the Condominium Act to a system of land ownership to which it cannot be applied by the very language of the Act. Because the Act itself says that it only applies to deeds registry areas, meaning transport areas. So the Honorable Member Annette Ferguson, when she was Minister of Housing, and they took the land at somewhere in the East Bank, what's the name of it? At Perseverance, and they built the houses, the duplex houses, with the intention of issuing title to those homeowners under the Condominium Act. Because Perseverance was a land registration area, no title could have been issued. And that is the dilemma that they found themselves in. I don't think up to now she understands that dilemma. And that is why titles could not have been and cannot be issued for any structure that purports to be a condominium if that structure is constructed on an area of land for which transport cannot be issued. And that is a major flaw of the Act, and this bill seeks to remedy that by making this bill apply to both transport and land registration areas. And that is set out clearly, I believe, in section 19 of the bill. Another important issue that this bill addresses, and which can be regarded as a deficiency in the current law, is that in Guyana, we recognize one of two instruments, or better put, two instruments as conclusive title to immovable property: a certificate of title and a transport. Those are the two instruments in law that we in Guyana accept as conclusive evidence of title. Under the law, when you buy a condominium, even if it is under a transport system, you do not get a transport as the title. You get an instrument created by the Act called a certificate of sale. So the Act produces an instrument that is alien and unfamiliar with our understanding of what is a titular owner in relation to immovable property. And though the Condominium Act, to the credit of the drafter, says that that certificate of sale is as good as a transport, the commercial banks of our country, the insurance companies of our country, and even lawyers and the deeds registry and the commercial and the land, well, the land registry doesn't come into play. They do not regard that title with the same legal force as they would regard a transport or a certificate of title. So though the condominium owner has what is akin in law to a transport, he cannot use it effectively and effectually because the commercial institutions of our country, including commercial banks and insurance companies, were not and are not accepting it as evidence of title. So you take a certificate of sale to a bank for a mortgage, and they refuse to register, to use it as collateral to give you a loan. And that, whether rightfully or wrongfully, is the reality of the situation. This bill says that once you buy a condominium, you get a transport if it is in a deeds registry area, and if you buy a condominium in a land registration area, you get a certificate of title. The same position applies, for example, under the Public Corporations Act. The Minister of Finance has a power under that act, pursuant to an agreement of sale in relation to properties owned by a public corporation and sold, to issue what is called a vesting order. So when Gaisuku transferred all those assets to NISIL, Minister Jordan at the time issued a vesting order. Now both the Public Corporation Act says very clearly that the vesting order has all the force of a transport. But many persons who have bought from public corporations and have been given a vesting order have had great difficulty, similar to that experienced by the condominium owner, in getting that vesting order accepted as valid and effectual title by our commercial institutions and insurance companies. And what they have had to do is to go and get the registrar of deeds to convert that vesting order into an actual and physical transport. Right now, most of you are aware of a case involving the BK Wharf. There is a vesting order, but the company that was the beneficiary of that vesting order under that challenge sale went to the deeds registry and got a transport and did not accept the vesting order.
Honorable AG, I think we should not refer to that part.
Yeah, so I just give that as an example. I'm not getting into the merit of the case at all, sir. I just want so that listeners who are listening to this debate, Mr. Speaker, can relate to what we are speaking about. It's important when we speak in this House that we understand the concepts. So that is one of the main reasons why this bill, Mr. Speaker, is being promulgated, to correct that titular deficiency that is inherent in the current law. Mr. Speaker, the other issue is as it relates to insurance. Now, under the current regime in the Condominium Act, it allows for under-insurance and it allows for double insurance. So one insurance policy is issued to the corporation to insure all the units. And the Act expressly allows for that insurance not to be equivalent to the value of the entire unit, and allows the unit holder to go and get additional insurance. Nothing wrong with that, except that the Act says that when that additional insurance is issued, so you have double insurance, the insurance company is compelled under the law to pay both the corporation if there is a destruction of the property insured, as well as pay under that other insurance policy of which the unit holder executes. So the insurance companies were refusing to insure any property under this law because of that patent deficiency. Mr. Speaker, that is cured in this act. And while the corporation is allowed to insure, unit holders are allowed to insure, but the insurance are separate and apart, and there is not double contribution, nor is there double compensation if there is a destruction of the property insured. These are serious deficiencies, Mr. Speaker, that afflicted the current law that this bill seeks to regularize. Mr. Speaker, we heard a lot about consultation. The Honorable Minister of Housing detailed the number of consultative engagements that were embarked upon and listed the number of agencies consulted. The entire private sector commission was consulted, the banking sector was consulted, the insurance companies were consulted, and hence we know the deficiencies. The Bar Association was consulted, and we have written evidence of the engagements because they were exchange of documents. The people of Guyana want this legislation. We campaigned on this legislation in our manifesto. We made promises that we will incorporate and bring a modern amendment, condominium law, and Mr. Speaker, we were elected upon that manifesto and upon those promises. In any event, we heard a lot from the Honorable Member Annette Ferguson that, oh Lord, they knew about the deficiency of the laws. They knew herself, the Honorable Member and Mr. Saul, they knew about it and they were engaging. Well, what came out of the engagement? As we heard, 47 odd families are still languishing as tenants for properties that they purchased for which they should have been issued title. That is the reality. So you can consult and you can engage. That has always been your modus operandi. You always fall short of delivering the goods and services to the people of Guyana, which we are doing here in a bill. Comprehensive, modern, and forward-looking. Mr. Speaker, so the honorable members speak about they were not consulted. The opposition were not consulted. Well, we are going to deal with a bill later, Mr. Speaker. We are going to deal with a bill later that was passed in the House after the government was defeated by the government alone in the absence of the opposition and anyone else in this House. So when you talk about not being consulted, we will deal with that bill in a short while. Mr. Speaker, the third important element of this bill is it sets out a process that hopefully will become a permanent feature in legislation that we will be bringing to this House. And it is a feature that seeks to remove bureaucratic hurdles in the public system, the public central government system, state agencies, and at the level of ministries, and to replace it with an expedient machinery that will process people's applications in a timely manner. And that is why, Mr. Speaker, when this bill is carefully and sensibly examined, it will see that the process that it outlines for the bringing into force a condominium scheme has a significant tenuous element. And it details, Mr. Speaker, that the application has to be made to the minister. However, it imposes upon the minister a serious duty to act within a time frame specified once the minister gets actual receipt of the application. 3 months is the time specified. And if that minister fails or refuses to either process the application, reject the application, or request additional information, that application is deemed to be approved. Mr. Speaker, that is the type of efficiency and expediency that we are injecting into the public decision-making process of our country. There is no other legislation, I think, that has this element. And as I said, we hope to make this a permanent feature of legislation of this type that requires the public bureaucracy and machinery to process applications from the public. Public officers, including ministers, will not be allowed to have documents on their desks for a protracted period without actioning them. If that happens, then there is a default mechanism that processes the application as being granted. And Mr. Speaker, that is a positive feature of this bill. The bill also, Mr. Speaker...
Before you get into the also, you will need an extension. And just for the Honorable Member, Mr. Mahipal, if I need your help, I wouldn't shout for it. I will gently and like a gentleman send you a note. And if you have a message for me, I suggest that you do likewise.
Mr. Speaker, I ask that the honorable member on the floor be granted an extension to conclude his presentation.
Thank you. Thank you, Mr. Speaker.
I'll grant an extension of 5 minutes to conclude.
Thank you, Mr.
Honorable
Speaker. So, Mr. Speaker, there is this time frame, and where the minister requests additional information or requests an amendment be done, or there is a request for an amendment to be done, the clock is adjusted and it goes on to tick, but the process is being timed. So there is no unnecessary delay. Mr. Speaker, the system also has some inherent facilities of fairness that allows the minister to grant a fair opportunity for the person's cases to be presented. And if the minister decides to reject an application, he is obliged to provide reasons in writing. Mr. Speaker, importantly also is the mortgage aspect of this bill. Under the current law, one can buy a unit out of a larger condominium complex that is mortgaged. So you can buy subject to a mortgage. This bill renders that impossible. What this bill does is that when the owner, assuming that the owner has a mortgage on the whole edifice and he wants to sell one unit, this bill allows that mortgage to be disaggregated and removed from that one unit. If that person is paying cash, that cash money goes into the bank to liquidate that mortgage, so you get a clean title free from the lien of that mortgage. If that potential purchaser requires a mortgage, then the mortgage is lifted to permit an unencumbered sale, and then the bank comes in and puts on back the mortgage on the property, but in the name of the new owner. That, Mr. Speaker, was not available in the old law, and that is a fundamental feature of this bill, so that it allows for persons to get title free from a lien, but at the same time, it facilitates borrowing and allowing the property, the unit, to be used as collateral against which that borrowing can take place. Mr. Speaker, a lot of the bill is procedural and tells you how the scheme is to run, etc. And then the other important part, Mr. Speaker, which I want to address quickly, is when there is a dissipation of the scheme. There can be a dissipation of the scheme by a voluntary winding up. Obviously, if you understand how the corporation is to work, the corporation is made up of the owners of the unit that constitute the singular edifice called a condominium. So it's not a corporation. I heard somebody speak about audited financial statement. My friend, it's not a corporation of that type. Of course, the corporation has a statutory duty to keep accounts, and there's a part of the law, part of the bill, sorry, but it's not that type of corporation. The Companies Act kicks in at occasions identified in the bill. For example, if you want to bring the corporation into liquidation, and that will either be done voluntarily or involuntarily, as the case may be. If it is voluntary, it's quite simple. You take a vote, and there is a way that the voting is done, and you make decisions that would affect the ultimate demise of the corporation as a unitary joint property. There is also a provision that allows you to go to court if you want to dissolve the corporation. And there is also the eventuality where the property is destroyed. If a majority of the units, for whatever reason, are destroyed, then there's a decision that has to be made within a time specified in the bill, either to continue as a corporation or to let it dissipate. Whichever eventuality unfolds, once the corporation dissipates, then the owners of the individual units become singular owner, and they own that part of the unit for which they hold transport and the land upon which it stands on. They will not have that community ownership. They will not have the common amenities to enjoy as a collective and all the other facilities that go with a condominium. They will simply be owning properties side by side. As for example, you own them now when they were occupying them as duplex houses. You can get individual title with a common party wall arrangement. Mr. Ramjatan, an experienced lawyer, will know about that. So you can have two joint houses or range houses and still not call them a condominium. Or you can bring that very structure under the Condominium Act. So if you wish to disengage, you continue to own that, but now you will have a joint arrangement with the person whose wall touches your property in that adjacent way. So, Mr. Speaker, there are many, many other important components that are in this bill that are virtuous and should be spoken about, but time is against me. Importantly, Mr. Speaker, this bill is one of the most modern expression of its type in this hemisphere. We consulted, Mr. Speaker, countries such as St. Lucia, St. Vincent, the Bahamas, Trinidad and Tobago, Jamaica. We consulted Canada in particular, Ontario, New York, and some other Turks and Caicos Islands, etc. And we extrapolated a set of provisions and fashioned a bill that would be unique and satisfy the peculiarities of our country and our society. Mr. Speaker, this is an excellent piece of legislation and I support it fully. I thank you very much.
Thank you very much, Honorable Attorney General. Now for the Honorable Prime Minister, the Honorable Mark Phillips.
Thank you, Mr. Speaker. Mr. Speaker, I rise to give my full support to the condominium bill, which our government has seen the need to prioritize and address urgently in order to bring yet another form of relief to our people. In this case, the 47 house owners who's been so adversely affected by the inactivity of the previous government. Mr. Speaker, due to the significant number of complaints received by persons who opted for the condominium-style houses, or as the APNU-AFC call them, duplexes, our government has been forced to bring this bill to the National Assembly as a form of rescue. Mr. Speaker, the APNU-AFC government, sometime between 2015 and 2017, had a bright idea of constructing duplexes as an initiative to provide housing to Guyanese. But as is typical of the APNU-AFC, no idea is ever well thought out, and the people are left to face the consequences of their incompetence. Mr. Speaker, all the excitement of the duplexes provided by the former administration soon turned into dismay for many Guyanese. Our citizens were given a housing option that created difficulty for them, with no actions being taken by the APNU-AFC while they were in government to remedy it. Mr. Speaker, the former administration implemented a housing project without first ensuring that it was thorough and covered all bases. Imagine, members of the House, imagine giving houses to people who are looking forward to home ownership, only for those persons to find out that there is absolutely no law that provides any protection for their hard-earned money, which they invested, and not being able to even be granted a title to show for their accomplishment of home ownership and security for themselves and future generations, something that is a milestone in many persons' lives. All this was what the APNU-AFC offered to our people. Clear lack of vision, which resulted in a big failure, and who was left to face the aftermath? Who was left to face the aftermath? The Guyanese people who put their trust and confidence in the last APNU-AFC government. Mr. Speaker, the persons who occupy those homes are not the only ones who face difficulties, but banks and private investors too were affected, as you heard before. The lack of legal framework hindered banks from being able to provide support to many, especially young people and poor families who needed loans. Private investors too, who explored this avenue for investment, also found it difficult, as the laws simply did not exist. But yet, we had a government offering this to the people and hearing of the difficulties, but do what they do best. Nothing about any of it. That's what they do best. Nothing. And that's why you remain over there for a very, very long time. Because the people of Guyana want a government that can deliver. Mr. Speaker, yet again, Yet again, our government has to do the work the AP and UFC could not properly do. So here we are today, hoping that the opposition will support this bill, which really supports providing security and ease for our people so that they can be dignified homeowners, and also providing the legal support for not just homeowners, but investors and the financial institutions who play a major role in development, especially now with the rapid development taking place in Guyana for the future. Mr. Speaker, this bill will lay the foundation for condominiums to be built and sold with access to services from banks, insurance companies, and for titles to be granted for individual home ownership as set out in the law. Mr. Speaker, I wish to point out that the power which will be given to the Minister of Housing will help to regulate the construction of future condominiums so that standards are maintained. Mr. Speaker, for instance, we found that even with the duplexes constructed by the previous government, the size of the individual lots on which the units were constructed did not meet the standard minimum requirements, 40 feet by 80 feet. This new law, Mr. Speaker, will allow the minister to be able to review relevant documents and through his technical team, advise investors before giving approval. Mr. Speaker, with this legislation, Guyana can now move forward in the direction our government envisions for the development of our housing sector and our citizens. These amendments, Mr. Speaker, which are necessary for those who access the duplexes provided under the APNU AFC, will now pave the way for titles to be made available to them. They will now be able to access insurance policies and bank loans. We will also be able to use the titles as collateral to provide loan access to those homeowners. Mr. Speaker, I invite, and I'm happy to hear that the opposition members of this Honorable House join us in support of this bill, which is just another one of the many ways being paved for our country's economic development, as well as the development of the lives of our people. Mr. Speaker, this bill is just part of a basket of relief measures by my government, by our government, a caring government to the people of Guyana. Mr. Speaker, if you look at today's paper, and you will see, you don't have to look far. We know that the bill, Mr. Speaker, was 65 pages of easy reading for me, but difficult reading for members of the opposition. I read the 65 pages while listening to Al Jazeera and being amused by In the Ring. They could have read the 65 pages, but failure to read the 65 pages does not mean that you must be ignorant of what is taking place around you. Look at today's paper. Government announces more groundbreaking measures to cushion rising costs of living. Special one-off grant of $25,000 to every single household in riverine and hinterland communities. Removal of VAT on sheetrock and concrete board will impact on housing. 1 billion water fertilizer for free distribution to farmers. Construction assistance for household owners. Mr. Speaker, It is repeated here again. I don't want to read it again, but it is repeated here. And it is repeated again in another paper here, Mr. Speaker. Mr. Speaker, you recall before we were apprised of other measures that brought relief to the people, like the removal of VAT on cement, the removal of tax on petroleum, oil, and lubricants. Mr. Speaker, all these are just measures of a caring government. Mr. Speaker, there is no need for us to defer the implementation of this bill to any select committee. Mr. Speaker, in the realm of justice, we are told that justice delayed is justice denied. In governance, development delayed is development denied. Let us all support this bill. Thank you, Mr. Speaker.
Thank you, Honorable Prime Minister. And to close this debate, the Honorable Minister of Housing and Water, Mr. Colin Cole.
Thank you, Mr. Speaker. Mr. Speaker, for the past few hours, if you listened to the presentations that have been made, and I first of all want to thank my colleagues on this side of the House for their support of this modernized legislation, the condominium bill. I'll respond to you in a few minutes. But, Mr. Speaker, if you've listened for the past few hours, you will realize why we are on this side of the House. And that is because there's an expectation by a nation for us to bring betterment and relief to the people of Guyana. And that is what we intend to do as a People's Progressive Party civic government. And so one means in which we will do that is through legislation. And legislation are intended, more oftentimes it derives from a necessity and also to bring a relief, hence the condominium bill. The other, Mr. Speaker, I am still perplexed because the opposition said they support the bill, but on the other hand, they wanted to go immediately to a select committee. So they need to make up their mind, first of all, as to the direction they would like this bill to go in. But, Mr. Speaker, it would be remiss of me if I do not remind and repeat and thank some of the persons who were involved in this bill. First of all, I want to start with Mr. Darshan Ramdani, and supported by Ms. Arya Redheath, attorney at law and legislative drafter. And may I remind, a lot has been said about consultation. I have with me here, Mr. Speaker, these are the written submissions by various stakeholders who were consulted and who provided their views, their opinions, and feedback, and allowed us to craft this bill. Mr. Speaker, may I remind and thank, I don't know if you have to guide me, am I allowed to name persons who represented the organizations? Okay, good. May I thank Adel Farrier, Credit Risk Manager for Scotia Bank. I'm coming to you, AG, don't worry. But we want to speak about consultation, so I'll give you the real people who are involved. Venus Fritz, Credit Manager, Republic Bank. Neville Skit, Manager of Credit Department, Citizens Bank. Kaladin from Bank of Baroda. Simone Clifton, Credit Officer, Hand in Hand Trust. Juanita Critchlow, Assistant Company Secretary, IPED. Kemraj Gubadan, Deputy General Manager of Diamond Insurance. Melissa DeSantos, the CEO of Demerara Mutual, Demerara Fire. Mary Nagasar, Fire Manager for Hand in Hand Mutual. Patricia Passad, Assistant General Manager of Asuria Guyana Inc. Rebecca Abdullah, Compliance Officer, CARICOM General Insurance Company. Sean Seaton, NAFICO. Sean Salim, Fire Manager of NAFICO. Diana Passad, Branch Manager, Massey United Insurance. Vikash Pandey, Director of PMP Insurance, Brokers and Consultants Limited. Asha Arthur, Fire Manager of Demerara Mutual. Sherry Hewitt, Tara Chandra, Diamond Mutual Insurance. And then we also had follow-up consultations with the Association of Bankers. Adeli Fario, Credit Risk Managers. These are follow-up, these not one. Credit Manager of Republic Bank, Venus Fritz. Kimberly Samaru, Executive Director of Guyana Association of Bankers. We also received independent submission from Guyana Bar Association of Guyana. And so, as well as the registries, these are the Registrar of Land, the Registrar of Deeds, they were also consulted. Mr. Speaker, you will realize the real players who were affected and the people who will have to be involved when we're going to deal with ownership, whether it's a condominium, whether it's town hall, whether it's for apartments, the real people who will have to provide that guarantee, whether it's for ownership, for a loan, whether it's for insurance, whether it's for title, processing of title, these were the people who gave direct input on this bill. So, Mr. Speaker, and it is our intention to continue the pattern to bring to this House responsible legislation. And what do I mean? I've outlined in my opening remarks whereby we have placed responsibility on the minister, bounded by timeline and bounded by explanation for any decision that has to be made. Isn't that modern legislation? Mr. Speaker, and more importantly, if there's no response by the minister, then it will be deemed as being approved. And if you think we have started in this format with this bill alone, wait until when you see us bring later this year, when we will be addressing the electronic single window processing unit, which will have with it legislations that will have time bound for agencies that are involved in providing their feedback or their no objection or objection. So it is in our intention, as part of our modernized legislation, is to have all those agencies, for example, that will be involved, the Fire Board, Guyana Mayor, the local authorities, whether it's the municipalities, the NDCs, and in the absence of those local authorities, the regions, they will all be provided with time bound. whether it is the Environmental Protection Agency. So no longer will we have bureaucrats in the system stymieing development. This is how this PPPC government intends to govern for the people of Guyana. Mr. Speaker, mention was made about us passing legislation that has political consideration. I find that a very strange comment by the supposedly former Minister of Housing, well, responsibility for housing. Because this very minister, when transferred from the Ministry of, well, they didn't call it Public Works and was what? Public Infrastructure, took months before she even, and the honorable member entered the halls of the then Department of Housing on Brick Dam. Didn't even take up her position for months. And having said that, it is this very minister, then minister, who had the responsibility after her predecessor, if she wanted to correct an implementation of a project of construction of duplexes to ensure that persons received ownership, had the opportunity from 2017, and I'm using your period, pardon me, I don't need to shout, I can turn off the mic and speak, don't worry. Had the opportunity, even if you're using the no confidence motion, had the period of 2017, because the no confidence motion was not passed until December 2018. Come to this house and provide a frivolous and hiding under the purview of no confidence motion. But the no confidence motion didn't prevent you from budgeting for resources and didn't prevent you from bringing other legislation when you alone sat here and passed it. Isn't that hypocrisy, Mr. Speaker? Mr. Speaker, much has been said in the outline on this bill, and I do not wish to repeat them, except to say that it is our intention to very quickly, when this bill is passed, to put the necessary administrative procedures in place, because with it comes the responsibility of the regulations. And as I alluded earlier, the fees under the regulation, it is our intention, it will be set in parallel to what you can find at the land registry as well as deeds registry for similar transactions. And so I thank all persons who spoke on behalf and supporting this bill. I thank all persons who worked behind the scene, including some of the hard-working staff of Central Housing and Planning Authority here, led by the head of the legal department, Ms. Hanifa Jordan, Ms. Jermaine Stewart, the head of our planning division, who worked as a team with the consultants to ensure that the necessary engagement was done. And of course, I cannot close without thanking the support that has been provided by the Honorable Attorney General Mohammed Andir Nandalal and his team from the drafting division of the Attorney General Chambers. I thank you, Mr. Speaker, and I therefore use this opportunity to ask that this bill be laid and read a third time.
Thank you, Honorable Minister. Honorable members, I now put a question that the bill be read a second time. Those in favor say aye. Those against say no. The ayes have it. Let the bill be read a second time.
Bill 2022, Bill number 4 of 2022.
The House will now resolve itself into committee to consider the clauses of the bill.
Yeah.
Honorable members, I see there is one amendment that the minister is moving, and that is at clause 4.2 of the bill. So I put the question that clauses 1 to 3 stands part of the bill, and I propose the question that clauses 1 to 3 stand part of the bill. I now put a question that clauses 1 to 3 stands part of the bill. Those in favor say aye.
Aye.
Those against say no. Ayes have it. Clauses 1 to 3 now stand part of the bill. I now propose the question that clause 4 stand part of the bill. Honorable Minister.
Mr. Speaker, I wish to make an amendment to clause 4.2, deleting the last 3 words to the registrar. And so therefore that section to read, a proposed declaration and proposed description submitted for the approval of the minister in accordance with subsection 1 shall be accompanied by proof that such fees as may be prescribed have been paid.
Thank you, Honorable Minister. Honorable members, I now put a question that clause 4, as amended, be part of the bill. Those in favor say aye.
Aye.
Those against say no. Ayes have it. Clause 4 as amended now stands part of the bill. Honorable members, we have now from clauses 5 to 65. And I propose the question that clauses 5 to 65 stand part of the bill. I now put a question that clauses 5 to 65 stand part of the bill. Those in favor say aye.
Aye.
Those against say no. Ayes have it. Clauses 5 to 65 now stand part of the bill. Honorable members, I now put a question that the bill, as amended, be reported to the Assembly. Those in favor say aye. Those against say no.
Aye.
Ayes have it. Let the Assembly resume. Honorable Minister of Housing and Water.
Mr. Speaker, I rise to report that the Condominium Bill 2022, Bill number 4 of 2022, was considered in committee clause by clause and was passed with amendment to section 4.2. I now move that the bill be now read the third time and passed as amended.
Honorable members, the question is that the bill, the Condominium Bill 2022, Bill number 4 of 2022, be passed, be read a third time and passed as amended. Honorable members, those in favor say aye.
Aye.
Those against say no. Ayes have it. Let the bill be read a third time.
Condominium Bill 2022, Bill number 4 of 2022.
Honorable members, we will now move to the Nurses and Midwives Bill 2022, Bill number 6 of 2022, published on the 8th of April 2022. And I understand that the Honorable Member, the Attorney General and Minister of Legal Affairs, has had the permission of the Honorable Minister of Health to move the second reading of this bill on his behalf. Honorable Attorney General and Minister of Legal Affairs, the Honorable Anil Nandla.
Thank you very much, Mr. Speaker. Mr. Speaker, I said many times before, and I'm going to put it now on the permanent record of this National Assembly, that in over 250 years of recorded history, no other government has refused to resign when a no-confidence motion was passed against them other than the APNU AFC government between 2015 to 2020. Mr. Speaker, it is now a matter of public notoriety that on the 21st of December 2018, the PPP Civic, as a political opposition in the then Parliament, moved a no-confidence motion against the sitting APNU AFC government. 21st of December 2018, I hear the utterance greed for power. But Mr. Speaker, let me again put on the record that the Constitution of the Cooperative Republic of Guyana allows for a no-confidence motion to be moved against an incompetent and efficient government, and one was moved and passed. Mr. Speaker, the Constitution is very clear. Article 106.6 and 106.7 of that Constitution sets out in clear language what is to happen when a no-confidence motion is successfully passed. 106 says, and Mr. Ramjitan, please pay attention. 106 says, the cabinet, including the president, shall resign if the government is defeated by the vote of a majority of all the elected members of the National Assembly on a vote of confidence. I am going to get to the bill. Be patient. I have a long time here to speak. It's an entire bill I have to speak of. So on that very eventful and historic day, this no-confidence motion was passed. And the Constitution, and there are many persons on that side, Mr. Speaker, like to speak about an installed government, and they like to speak about constitutionality. But when that no-confidence motion was passed against them on Stream Live, the Constitution immediately mandated them, beginning from the President and the Cabinet, to resign, using the term shall resign. What did they do? They remained in government from 2018 until they were voted out of government on March 2nd, 2020. Then they squatted for 5 months in government until August 2020. And these persons in this house want to lecture us here and the Guyanese people about democracy and constitutionality. And Mr. Speaker, we never put Mr. Ramjatan constructed a list of candidates to go to those elections, and he freely and voluntarily placed persons on that list. But they were so ineffective and so inefficient that the people that they put on the list vote against them. Whose fault is that? Whose fault is that, Mr. Speaker? Whose fault is that? It is a matter for you to wash your dirty linen in the public domain. Nobody cares about you and your internal problem. The gentleman gave an interview and he said that you were an incompetent leader, you were ineffective, and he had no voice in the government that he supported. As a result, he voted against you.
Attorney General, I think at this time the you refers to me.
Yes, sir.
So could you say the honorable member, Comrade Ramjatan?
Yes,
so
Comrade
we know
Ramjatan.
who you're speaking about.
Comrade Ramjatan. Comrade Ramjatan, the honorable member. So, Mr. Speaker, the Constitution also says that notwithstanding its defeat, the government shall remain in office and shall hold an election within 3 months or such longer period as the National Assembly shall by resolution supported by not less than 2/3 of the votes of all the elected members of the National Assembly determine, and shall resign after the President takes the office following that election. Well, Mr. Speaker, it is also a fact of public notoriety that they refused to hold the elections also while he squatted in office for that 3 months. And Mr. Speaker, is not that they were not aware, because ignorance of the law, as you know, is not a defense. It's not that they were not aware that they could not have gone back to Parliament, because the Constitution says they can come back to Parliament, but for one reason: to get an extension beyond the 3 months period. Mr. Ramjatan speaks about court matters. So rather than resign and do the decent thing, Mr. Speaker, they got the Attorney General of the day to find a farmer somewhere in New Amsterdam and then retain 2 senior counsel on Crowell Street to retain that farmer, to sue him, the Attorney General, and use $28 million state funds to pay the 2 senior counsel. The first Attorney General on planet Earth who pay with public monies for someone to sue him in office. That is what happened. So they challenge the no confidence motion. And Mr. Speaker, no, this is very relevant, Mr. Speaker. This is the reason why the bill is here. But allow me to, I am going to traverse this journey carefully and slowly. So, Mr. Speaker, the grand plan was that the Attorney General would have been sued by an action inspired and paid for by him against himself, and he would have quietly gone to court and consented to the judgment and set aside the no confidence motion. Brilliant plan, carved out by a brilliant individual. Well, that didn't happen. We know, Mr. Speaker, and we joined the proceedings and we upset the apple cart. And the matter went all the way to the Caribbean Court of Justice, where the court told them that they were a caretaker government, that the Constitution is clear, and that they should honor it. Decency dictated that they honor it. Let me quote from what the CCJ in the judgment said. This is what they said at paragraph 8.
Mr. Speaker, on a point of order, I ask that you bring the circus to an end. The Honorable Attorney General is obviously...
Honorable Member, Mr. The standing order you have to quote, and then you have to allow me to adjudicate the applicability of that standing order. Good, so please, Honorable Attorney General.
Yes, thank you very much, sir. So, sir, the CCJ ruled, this is what they said at paragraph 8. In mandating that the government shall remain in office, notwithstanding its defeat and resignation of the President and the Cabinet, Article 106 envisages that the tenure in office of the Cabinet, including the President, after the government's defeat, is on a different footing from that which existed prior to the vote of no confidence. The court then quoted Chancellor Cummings, who cited the text Hogg, Canadian constitutional law expert. And Hogg said this: the government continues in office as a caretaker government or an interim government until the next election ensues and a president is elected. So, Mr. Speaker, it is clear. It is clear. It is clear. So let me, Mr. Speaker, let me answer Mr. Ramjatan. Mr. Ramjatan seems to think, honorable members seem to think.
Well, Honorable AG, you know, you've spent 10 minutes of your first 4 to 5 minutes.
Yes.
In this preamble. So
yes.
Can we get on
so, Mr. Speaker, the CCJ, Mr. Ramjatan seemed to think that after the defeat of the no confidence motion, that it maintains the same power.
We have to look at the decorum of the House. You know, for the last 10 minutes, you're referring to the Honorable Comrade Ramjatan.
Yes.
Right? And you didn't, once I think you used comrade. Please. We just had a seminar about decorum and all these things.
So, Comrade Ramjatan continues to labor under that serious delusion that after a government is defeated by a no confidence motion, it retains its full plenitude of power. I can't believe this degree of ignorance. After all that we went through, after so many rulings from the court, learned counsel still is telling the Guyanese people that the position before and after no confidence motion is the same. Let me correct that delusion, hopefully once and for all. The CCJ said, and I quote, by convention, the government is expected to behave during this interim period as a caretaker and so restrain the exercise of its legal authority. Oh my God. Does it sink in, honorable member, comrade? You have to restrain your legal authority. So, Mr. Speaker, it is clear to the Guyanese people that the honorable member, Mr. Ramjatan, still doesn't understand the Constitution and the effect of a no confidence motion. And of course, that is why, Mr. Speaker, on the 4th of January 2019, that is just over a week after the no confidence motion was passed, and in the absence of the opposition being in the House,
Mr. Speaker,
the Midwives and Midwives Act of 2019.
Thank you. Mr. Speaker, Standing Order 41, Contents of Speech. 1. I rise on that standing order, and I would like to quote it. Subject to these standing orders, debate upon any motion, bill, or amendment shall be relevant to such a motion, bill, or amendment. And a member shall confine his or her observation to the subject under discussion. And is that we are currently supposed to be debating the nurses and midwife bill, Mr. Speaker.
Thank you for the observation, Honorable Chief Whip. Honorable AG, you may continue.
Yes, sir, thank you. So, sir, notwithstanding the defeat by the no confidence motion, notwithstanding the clear language of the Constitution that they are a caretaker government with limited executive power, that government on the 4th of January 2019 surreptitiously came into the National Assembly and debated and passed the Nurses and Midwife Act of 2019. Mr. Speaker, is that registered? Is the relevance seen? Are you understanding why the preamble? Notwithstanding the defeat by the no confidence motion, you surreptitiously came into the House in the absence of the opposition and debated and passed the Nurses and Midwife Act of 2019, which a president who was mandated to resign by the express language of the Constitution then proceeds to render a purported assent to it on the 23rd of January 2019. This is the height of lawlessness. The height of lawlessness. And then we have honorable members on that side speaking about they not being consulted for legislation, when they passed an entire bill, debated it by themselves, and as a defeated government, and take it to a defeated president for his assent. Mr. Speaker, that law is invalid, it is null, it is void, and it is of absolutely no effect. And that is why, Mr. Speaker, we are here today with this bill. This bill seeks to, we have to put a repeal clause in it for the record, because the current defective bill purports to be, on its face, a law of Guyana. And a court has not pronounced upon it. Nevertheless, notwithstanding the fact that it is null, void, and of no effect. And because of that, and to be complete, there is a clause in this bill that repeals that law. I should also put this on the record that this bill, the Nursing and Midwives Bill, is a bill also that came out of the People's Progressive Party administration between 2011 and 2015. So it's not even their bill that they were going to put through that bastardized process. It was a bill that they found on their desks when they assumed government in 2015. It was a bill that was already drafted and on their desks. And that is what the bill, however, Mr. Speaker, is very important as it creates a very important infrastructure structure for nurses and midwives. And that is why, Mr. Speaker, we have decided to bring it back in National Assembly. And we are doing exactly what we did in relation to the Natural Resource Fund Act. Mr. Speaker, you would recall that that is also an act that they brought to the National Assembly after their defeat by the no confidence motion, and they foisted that in their illegal state as a law of this country. And we brought a law, a bill, and we repealed that last December. We are simply doing the same to remain consistent and to remove impure and impugned laws from our statute books. So, Mr. Speaker, those are the few remarks that I would like to express, and I commend this bill to the House to be read a second time. Thank you very much, Mr. Speaker.
Thank you, Honorable Attorney General. And now for the Honorable Member, Ms. Dawn Hastings Williams, to make her contribution.
Thank you, Mr. Speaker. Mr. Speaker, before I make my contribution on the bill that is now being considered, I wish to do a few rebuttals. Mr. Speaker, we just heard the Attorney General talking about us on the APNU side, squatted, and all manner of descriptions, but I wish to place on record that the APNU, when we were about to bring a no confidence motion and the PPP learned about same, we were brave enough to allow the motion that it can be debated, unlike the PPP who prorogued the parliament. And Mr. Speaker, I also wish to speak and rebut on what the Honorable Colin Crowell, Minister of Housing, stated that, or talked about the latest announcement made by removing VAT on certain materials that can be used for construction. Mr. Speaker, I wish to put on record, is there any consideration for the people of the hinterland when making these statements in this honorable house? I say that, Mr. Speaker, and living in the hinterland for many years and still visiting there very often, going home, I wish to let the members of this house and the residents of the Upper Mazaruni and the other hinterland areas to know that removing VAT from cement, concrete board, and sheetrock, what does it do to help the people in reality? When, Mr. Speaker, a sack of cement costs approximately $1,600 here in Georgetown, to fly in a sack of cement to Camarang, whereas it is approximately 80 pounds for a sack of cement. And whereas, Mr. Speaker, a pound of weight on an airplane is $175 a pound. Multiply 80 pounds by $175, the landing cost of one cement bag will cost $15,000. $15,000 is the landing cost of one cement sack to Cameroon. One can only imagine what happens when you're going to transport the cement bag from Cameroon to Warramadang, to Porima, to Jawala, or to Kibanang, when the cost of gasoline at present is $2,600 a gallon. Mr. Speaker, where is the one Guyana that we are talking about? Where is this one Guyana that we are talking about, Mr. Speaker? We're talking about all these measures, but in reality, Mr. Speaker, the people in the hinterland are experiencing difficulty and are struggling. Are we not entitled to build a modern home too? Many of us want to live in a concrete house with sheetrock and the different galvanized, or are we, when we decide to build a modern house according to somebody, are we going to lose our identity? That's my question, Mr. Speaker. Mr. Speaker, let me now come to the bill that is now being considered. I wish to begin by speaking to section 52 of the bill, which speaks to the repealing of the current act. Mr. Speaker, I am not a lawyer by profession, but a legislator as a parliamentarian, and to my common knowledge, the purpose of repealing or rescinding a law is to modernize and simplify the statute. However, listening to the Minister of Legal Affairs, or Attorney General, I'm simply not convinced that this is the reason for repealing the Act of 2019. Hence, Mr. Speaker, I wish to quote from the former Minister of Health, one who has proven to be one of the competent health ministers this country ever had, an Honorable Valda Lawrence. And I quote, Mr. Speaker, this bill seeks to improve the welfare and well-being of every nurse and midwife countrywide and to strengthen the healthcare delivery systems. The bill also seeks to ensure compliance with the global standards and to simultaneously ensure that it is reflected in our local cultural setting, end of quote. Mr. Speaker, the Nurse and the Midwives Bill of 2018 established a new and improved covering body named the Nurses and Midwives Council to oversee nursing in Guyana in a more inclusive and transparent manner. Hence, Section 5, which states that the powers of the Council to train and set the required standards for the curricula of study for nursing. The composition of the Council also included a number of persons, including the Director of Health Sciences Education. What we are now seeing, however, Mr. Speaker, is that these very, very important sections of the Act are now being targeted for changes. Mr. Speaker, Section 35(5) has been excluded in the new bill because it is now irrelevant that they have changed the way the persons are selected to be the members of the disciplinary committee. These major changes being made in the new bills are major and mainly in section 5 and 35 that relates to the power of the council, as I said earlier, to regulate training, curriculum, examinations of nurses, and the composition of the disciplinary committee. My question then to this August House, Mr. Speaker, what positive impact does these changes or amendments have on the lives of our hard-working nurses, especially those working in the remote areas of our hinterland, and more so the people of this nation when it comes to the delivery of health care? Mr. Speaker, earlier we heard from the Attorney General challenging the then Speaker, Honorable Scotland, for having the Nurses and Midwives Bill of 2019 placed on the order paper and debated. Mr. Speaker, perhaps Mr. Nandalal, the honorable member, should be the Speaker of the House. Mr. Speaker, I am yet to hear from the remainder of the speakers on that side of the House what are their justifications for making the changes and repealing an excellent piece of legislation that was tabled and passed in this honorable House only a few years ago. It was by no means our fault that they were not here to debate on the bill then, when the Speaker allowed it to be debated. I also wish to place on record the call to retain the Director of Health Sciences Education to sit on the council than to just name a representative from the Health Sciences Education. Mr. Speaker, with that said, I now request that this bill be sent to the Select Committee for further deliberations. I thank you.
Thank you, Honorable Member, Ms. Hastings-Williams. And now for the Honorable Member, Dr. Jennifer Westford, to make her contribution.
Thank you very much, Mr. Speaker. Mr. Speaker, I stand to give my support to this bill that is long overdue. And, sir, it is so important and timely. And I agree with the Honorable Member, Ms. Hastings, that this is a very, very important bill to the lives of our nurses out there. But, sir, I think the Honorable Member, when she said that she doesn't see the need for the bill of 2019 being repealed, let us not forget, and the Honorable Attorney General reminded us that this bill was not legitimately passed in this House. And I don't know how many times would we have to repeat that, but the reason and the facts are that it had to be repealed so that it can be reflected in our history that it is now being done legitimately. Sir, this new bill that we're seeing here is a big change from the the ordinance of 1953. We can now see that that ordinance of 1953, it was so deficient. It was very deficient because, firstly, it was named the Nurses of the Sick and Midwives Ordinance. It did cater for a council, And that council that was responsible, that was supposed to be responsible for registration of nurses and also licensing of nurses, looking at their training. But sir, that was in the colonial days. And most of those things were, most of the regulations actually, even though that there was a council, was left for the governor to monitor those things. Since then, sir, we have had a revolution in the nursing profession. And it is for this reason, when the Honorable Attorney General mentioned that what we're seeing here today actually started around that bill, it wasn't anything, and I agree with him, it was not done under the APNU's reign in 2015. Sir, this bill, this started way before then. And the reason for this is that before then, we started all of the negotiations with the relevant players. We started negotiations with the private sector, in the health sector, because they started having nursing schools. For example, we had nursing schools in the Mercy Hospital, had a nursing school, and we had a lot of conflicting messages. The Georgetown School of Nursing, the Linden School of Nursing, they all had different syllabuses that did not correspond. So we started that in getting a legislation that would cover both the private and the public sectors, so that we had one national Guyana nursing council that would have been responsible for overseeing the quality of nursing education. And for that reason, Honorable Member Hastings, you mentioned about the changes, for instance, from the health sciences, the director, the amendments that are going to be made. Saying, in moving to say the director, or moving from director to saying a representative from the health education department, health sciences department, I think what that is going to give us really the opportunity for us to have a person, if we say the director, it may not be the person who is the most qualified to sit on that council and give advice. And I am sure lots of us, and especially those persons in the health sector, would understand what I'm trying to say. Mr. Speaker, again, sir, when we look at this legislation, as the saying says, it's cheese to chalk to what was there before. Again, it was necessary because by 2011, we already had started training a cadre of psychiatric nurses. We already had a cadre of pediatric nurses. We had some nurses in the anesthetic department, and we had the confusion as to how do we classify these persons. The very nurses, as well as their representatives at the level of the Guyana Public Service Union, they were saying, how do we classify them? They're specialists now. Where do we put them? The council did not cater for that. That old council we had did not say that we are registering specialist nurses. This new legislation is catering for specialist nurses. We are also seeing a different category here, which says nursing assistants. They were not catered for, sir. They were left in the wilderness, by the wayside. In that act of 1953, they did cater for an addendum to be placed for a category they called the nurses who gave assistance to mentally ill persons. That was the category. That's how they placed it in that act. They didn't call them because they were not specially trained as such. They were just working there. But we trained, sir. We saw the necessity, the PPPC government, we saw the necessity of training those persons, giving them additional training, and making them specialists within their own rights, so that it was advantageous to the patients who were receiving the care from them. Anyone would feel comfortable if they're in an obstetric ward, instead of having a generally trained nurse to say, hey, this is an obstetric nurse. Or here, my child is in the pediatric ward and they're being attended to by a pediatric nurse, a specialized nurse. So the necessity was there. And that is why the Attorney General could have said that this wasn't something implemented in 2015. It was there. It was there. And we heard the whole episode of why the PPPC could not pass that legislation, because we were not given the opportunity to do so. But, sir, I want to say that as we stand here, we, the PPPC government, we are proud, sir, of those category of nurses who we call specialists, that were trained because we saw the necessity of doing so. We saw the necessity of giving them that recognition, sir. We also had another issue where one of our very prominent, she was one of our nurses, our sisters, she was a tutor, Sister Tross, who came to Guyana, and in collaboration with the University of Guyana, they started the degree in nursing. And again, we had lots of nurses who did that degree, but then they were not recognized and catered for. We did not know what to do with them. When you're finished with that degree, what happens? Do you just come back and just sit there as a staff nurse or a staff nurse midwife? Are you eligible with that qualification to become a junior ward sister or give you? Nothing was there. So it was necessary for something to legalize that, to put them as a special category and legalize them. And sir, that is why I say this legislation is urgent, it's important, and it's late. It's too late in being here now, all because it was not here legitimately. And sir, I want to say, I might be a bit late because International Nurses Day was not too late, it was last week, to say that we appreciate the work that is being done, and we need to acknowledge that work being done by nurses. And this legislation is going to ensure that they're recognized. Each category would be recognized for the work that they're doing, and as well as the people out there, the patients they look at. I am sure they will be happy knowing that, look, we have a specialist here. When I walk into the ophthalmic department, I know here, this is a specialist nurse who is trained, and I can close my eyes or open my eyes and I know that I'm going to be properly looked at. So, sir, I want to, once again, I know we are going to be hearing quite a lot of untruths here today. We have heard some already. But, sir, I want to say, nurses, you are recognized by this government. You will continue to be recognized, and any legislation that we can pass to ensure that you will be given, sir, that the nurses, through you, that they're going to be given that recognition that they deserve. We will, without fear or favor, sit here, and we will ensure that those legislations are correctly passed and they get their due. Thank you, sir.
Thank you, Honorable Member, Dr. Westford. And now for the Honorable Member, Mr. Ronald Cox, to make his presentation.
Thank you, Mr. Speaker. I would have if I was on that side. Honorable Siraj, I would have if I was on that side. Because that's where it's coming from. Mr. Speaker, as I rise to make my contribution on the Nurses and Midwives Bill 2022, Bill number 6 of 2022, permit me to utilize a few minutes to make a few statements in response to some of the remarks mentioned before me. I want to first of all, Mr. Speaker, start by saluting the nurses across our country who have worked diligently, professionally, and had made all sacrifices in the well-being of the health of this nation. And so we say thank you. Mr. Speaker, it was the Honorable, most experienced, learned Attorney General and other colleagues who from time to time mention and keep saying that the work of Parliament in 2019 was illegal and not legitimate. But sir, for 12 months of 2019, the very learned members of the PPC collected the parliamentary salaries, and these included the Honorable Bishop Edgell, the Honorable Gail Teixeira, the Honorable Dharmalal, and the Attorney General, the Honorable Anil Nandal. I specifically call these names because these are the most seasoned politicians in Guyana, and they would not come here to say we would do otherwise. They criticize and yet do the same thing. So I'm wondering, if you're talking about correcting something, I dare the honorable members of the PPC that collected the parliamentary salaries in 2019, if you may, return all to the consolidated fund. And then the people of Guyana will respect you when you speak about upholding the constitutional mandate of this country. Honorable Mr. Speaker, the Honorable Jennifer Westford spoke of the necessity for training of nurses. Mr. Speaker, it is under this very administration that the Linden Nursing School was shut down, placing majority of hinterland students in jeopardy. I call on this administration, if you are serious about necessity for training and nurses' professional development, reopen the Linden Nursing School and let's get nursing back to the business it was. Mr. Speaker, 21st century has presented several challenges to those responsible for training, development, and management of human resources for health. There is need to strengthen the quality of training, ensure the acquisition of job skills that facilitate a comprehensive response to the needs of users of health services, and improve the equitable distribution of these clinical resources. I have no doubt that this very bill before us seeks to do likewise. Mr. Speaker, it was my colleague, the Honorable Valda Lawrence, while she was the Minister of Public Health, vows to draft a policy which will tremendously benefit the nursing sector. Consequently, the Nurses and Midwives Amendment Bill was presented by the Honorable Member in 2018 and subsequently passed and accented to in 2019. This bill then seeks to empower the Nurses and Midwives Council to enroll, register, certified, and licensed nursing personnel, among other things. Mr. Speaker, the then minister said, and I quote, "The bill will also empower the council to take disciplinary actions against nursing personnel for breach of established standards of professional conduct and provide for the establishment of a discipline committee. I am sure that the present administration, well, I hope that the present administration has similar vision. And if they do, I want to say thank you for following in the step of the Honorable Valda Lawrence. The Minister further added that the amendment comes with great commitment by the Ministry of Public Health to improve the welfare and well-being of every nurse and midwife countrywide, strengthening the healthcare delivery system. Furthermore, the then Minister said, for years, the exercise for nurses to seek specialization within the nursing sector was cut, but with the passage of the bill, it has finally come to an end. Mr. Speaker, I was sitting there waiting for the Honorable Attorney General to at least go through some of the essential clauses of this bill so as to explain to new parliamentarians like myself how it will impact the nurses in Guyana. But the Honorable Attorney General resorted to preamble of a political campaign speech that I have so grown accustomed to in this parliament. Mr. Speaker, while we support this bill, we also call on the government to adequately train medical personnel so as to reduce the pain many mothers go through at some of our hospitals. Mr. Speaker, quality of training must be improved and professionalized. Systems must be implemented for nurses and midwives to improve on their daily tasks. We must seek to upgrade the nurses and to identify failures largely due to poorly equipped public medical institutions. Mr. Speaker, we must seek to remove any glaring deficiencies in the system and set into motion a program to strengthen our healthcare delivery. Mr. Speaker, in 2019, Dr. LaFleur remarked that the ultimate goal of regulations regarding the nursing profession is to protect the public from an unfit person performing the duties of a nurse or midwife. She further posited that the regulations refer to laws that define nursing practice. So it actually defines nursing practice and disciplinary measures. I want you to also know that nursing is regulated because it is one of the health professions that pose a risk of harm to the public if it is not practiced by someone who is prepared or competent. While this was a good observation, in 2022, Mr. Speaker, the people of the hinterland regions seem to be returning to being victims of poor healthcare services. Mr. Speaker, why only one midwife should be nominated to sit on the council when midwifery is a specialty and maternal deaths and misconduct have wreaked havoc over the public healthcare system? There is also a large migration of midwives due to a series of issues, including poor representation and recognition across the board. Over the years, we have witnessed a series of maternal deaths, and most recently at the New Amsterdam Hospital, as they have made headlines over the last few months. Mr. Speaker, in the interest of this, addressing these issues, it would be good to increase the midwives to 2 on the council, in addition to those mentioned in clause 6J under section 2 of this bill. Mr. Speaker, I wish to ask the Honorable Minister of Health, what about representation for the community health workers? How do you guarantee protection of these many community health workers who from time to time have to perform the duties of nurses, midwives, and even doctors in the most extreme circumstances without a representative body. These persons are the backbone of many health facilities across all hinterland villages in Guyana. And I know that many of my colleagues in the government side do know, is aware, and will not try to say that these things are not happening. The Honorable Colin Crowell, who traversed Region 1 quite a lot, would agree with me that community health workers are the ones who carry the healthcare system in those villages. Mr. Speaker, I wish to quote the PAHO WHO report titled Human Resources for Health, North Migration in Guyana. And I quote, "The health system has been adversely affected by continuing political conflicts, violence, poverty, inequity, and migration of qualified professionals. Lack of investment and human resource policies, low motivation, absenteeism, difficulties to retain station staff in remote areas have resulted in poor distribution and inequalities in healthcare provision." End of quote. This, Mr. Speaker, is what government must seek to address, coupled with legislative reforms. Mr. Speaker, Section 5 of this bill seeks to reduce an all-important scope of responsibilities of the Nursing Council. In the UK, Mr. Speaker, the Nursing Council makes provision that educational institutions meet standards for nursing education and that the Council sets, but they seem not to be involved in composing the curriculum and regulating exams. All of these are in this current act, while the new bill proposed seek to reduce that all-important responsibilities. I wish for the Honorable Minister to give clarity on the reasons for such and how the standards will be set and who then will be responsible. I would say, Mr. Speaker, that we must fight for standards in Guyana as it relates to this all-important health issue. And simply bringing a legislation all because you felt it was not properly done is not the important thing here. The important thing is for us to work together with our nurses, with our midwives, with our healthcare professionals to ensure that they are adequately represented and they receive the best that they deserve. Mr. Speaker, this bill, similar in nature to the 2019 bill, I hope will be very significant in its provision of modern legislative framework and effective management of the nursing profession in a developing country like ours. While I want to believe that this is the intention of the present administration, this bill is tabled at a time when nurses, especially those at the Linden Hospital complex, are struggling through actions largely created by an incompetent leadership. And so if we are competent, willing, and effectively seeking to upgrade the professional nursing system, then we must get rid of unprofessional leaders within the system. And until we do such, then the people of Guyana will respect the government and hold you responsible. We cannot speak to strengthening and modernizing the healthcare sector through capacity building and legislative reforms while ignoring the abuse of power by one or two persons who are obviously power drunk. Mr. Speaker, all nurses and midwives believe that a much needed hike in their salaries must support the new measures. Both categories of health workers have been pursuing higher learning, but are not financially rewarded by the public service. Consequently, many have opted for careers in the private sector or bolted for jobs overseas. For example, at one time, Guyana only had one psychiatric nurse remaining in the local healthcare sector. One, Mr. Speaker, one for our entire country. Mr. Speaker, we cannot stress legislative reform, and I keep repeating this over and over, and not seek to address the concern by nurses that a lack of consideration shown by the authorities for their welfare, that their non-involvement in decision-making affecting their professional life is pervasive throughout the healthcare system, and that there is no transparency in such decision-making. This was the vision of the APNU-AFC government while in government, and I'm sure this bill will build on that legacy left by the competent Honorable Valda Lawrence and the Honorable Dr. Karen Cummins, and by extension, the coalition. Mr. Speaker, notwithstanding all measures I have elaborated on, which are anticipated with the passage of this new bill, all healthcare professionals look forward to greater professionalism, representation, and of course, remuneration packages for their sacrifices. Mr. Speaker, in closing, again, I wish to thank all our healthcare professionals, especially our nurses, who continue, and even as we speak, we are not back to normal. The COVID pandemic is not over. And so we need to make proper representation, and we need to craft policies that will ensure that our nurses, our midwives, and other healthcare professionals remain protected and choose to remain in the profession. And so, Mr. Speaker, all those who have sacrificed their lives and the lives of their families, I want to say, we salute you, and we look forward to working with them in bringing a much modernized representation through this legislative reform. And I thank you, Mr. Speaker.
Thank you very much, Honorable Member Mr. Cox. And now to make his contribution, the Honorable Member, Mr. Vincent Henry.
Thank you very much, Mr. Speaker. Mr. Speaker, we listened a long speech given by the Honorable Nandalal, where he tried to justify that he and his government is not installed and are legitimate. But the majority of the Guyanese people know the fact. And when there was a big poll, the IRI poll, the people voiced that indeed they see this current government as being installed. And they are warming the seats there. Time very soon will come when you'll have to vacate it. Mr. Speaker, we also heard the Honorable Westford mentioning that the health workers, the nurses, the medical practitioners are recognized by this government. And I ask, what sort of recognition is there? How can you say you recognize the services and the sacrifices that the health personnel are giving to our people when you just do not want to give them the resources to make them be happy to make them look after their family, and to make them survive. And that is the reason why, even in Region 9, we have found that our local nurses are terminating their contracts and they're heading to other pastures, way over the trees, way into other colder countries. So how can you say you recognize them? I would say we are punishing our workers, our health workers, and the workers in general in Guyana. Mr. Speaker, I am pleased to examine the proposed Nurses and Midwife Act of 2022. This bill, I note, is described as one to make provision for the registration and regulation of nurses, midwives, nursing assistants, and specialist nurses, and for related matters. Mr. Speaker, at a glance, one would get an impression that this matter at hand is perfunctory, but after examining the details, it becomes clear that this proposed act is of utmost importance for the nation as a whole. From research, I have found that generally, the primary purpose of such a council is to protect the public health and welfare by ensuring that safe and competent midwifery care is provided by licensed nurses and midwives. The Council sets standards for the education of the practitioners and ensures that licenses are only granted to nurses and midwives who keep their knowledge and skills current and relevant and uphold the ethics of the profession. Mr. Speaker, the proposed act states that the Council of Nursing and Midwifery shall be a body corporate, but drops at giving a description of this, which is normally that it may enter into contracts, hold property, maintain bank accounts, and soon be sued in the name of the Council. Mr. Speaker, in terms of the function of the Council, I do propose that Section 4B could have reads, establish standards of education, training, conduct, and performance for nursing personnel, and to ensure that the maintenance of those standards are modified to read, establish standards of education, training, and I add remuneration, conduct, and performance for nursing personnel, and to ensure the maintenance of those standards. Mr. Speaker, unfortunately, in Guyana, the core issue in the problem is normally ignored. In this instance, the bill is seeking to create top-class professional nurses, but expect them to continue to labor for starvation salaries. Thus, Mr. Speaker, I humbly request that Section 4B be modified for the representatives of the nurses to make proposals to the government, the kind of remuneration that will keep our nurses in Guyana. Mr. Speaker, to continue to bury our heads in sand and hope the problem will go away would only force our nurses to go away from our shores to serve other countries because of the need to survive and to make living better for their families. Mr. Speaker, I note with concern in Section 6 that the Council shall consist of 15 members appointed by the Minister, and those positions are listed. However, Mr. Speaker, I note that there is no specific reference to any member representing the people of the hinterland. Mr. Speaker, please allow me to say that Guyana is not only the low coastal plain. Mr. Speaker, I wish to propose that Section 6G reads as follows. 4 members nominated by the Chief Nursing Officer as follows. 1, 2 registered nurses with 1 originating from and practicing in a hinterland region. and two nursing assistants with one originating from and practicing in a hinterland region. This is to get the input of the hinterland people. Mr. Speaker, Section 1 reads, the members who are not ex officio shall hold office for a period of 2 years and shall not be eligible for reappointment or re-election. Mr. Speaker, I wonder if this was a typographical mistake. Such an important body definitely needs institutional memory. And if a member performs well, he or she should not be thrown out with the baby water. Mr. Speaker, Section 34(4) states that a license issued under Section 3 is valid for the current year in which it is issued and expires on the 31st December of that year. Mr. Speaker, this proposal is not appropriate for Guyana. Those of us who know the difficulties associated with logistics in the hinterland cannot support this. Mr. Speaker, I do propose that this period be extended to 2 years. Even Jamaica, that does not have our challenges, has a period of 2 years for the validity of the license. Mr. Speaker, under Part 5, Offenses and Penalties, Section 44, it states, subject to Section 34(5), any person who practices nursing and midwifery in Guyana without being registered and holding a valid license, or B, any specialty of nursing without being registered as a specialist nurse commits an offense and shall be liable on summary conviction to a fine of $500,000 and imprisonment to 12 months. Mr. Speaker, this act should also have the ability to promote a caring, culturally sensitive, and ethically sound environment in which health services are provided. Mr. Speaker, the United Nations Declaration on the Rights of Indigenous Peoples recognizes the dual reality of many indigenous people live in two worlds. In one world, they hold fast to their cultural traditions, beliefs, and values. The other world is that of a colonizing nation, and it is where many indigenous people go for their health care. This is Article 24 of UNDRIP is essential to understanding these health rights, and it states, 24(1), indigenous peoples have the right to their traditional medicines and to maintain their health practices, including the conservation of their vital medicinal plants, animals, and minerals. Indigenous individuals also have the right to access, without any discrimination, to all social and health services. And 24(2) says, indigenous individuals have an equal right to the enjoyment of the highest attainable standard of physical and mental health. States shall take the necessary steps with a view to achieving progressively the full realization of this right. Mr. Speaker, with one stroke of the pen, the culture of the indigenous people is rendered to be unlawful and useless. Mr. Speaker, for centuries, the indigenous people practiced their methods of midwifery and traditional healing. Today, in most indigenous communities, there exists traditional midwives and healers. Will these midwives and healers be subject to the wrath of the law as defined in this act? Mr. Speaker, please allow me to propose that these traditional healers be recognized and registered by the village councils and the appropriate authorities in the indigenous villages, and that a policy and program be developed to allow these indigenous practitioners the scope to function. I was told before I came to speak here that this is already in train, and let us hope that it will be developed further. Also, Mr. Speaker, I wish to propose that when a registered or specialist nurse reasonably holds the that an emergency exists which gives rise to a serious risk of danger to life or health of a person, and no medical practitioner is available to attend to such an emergency, the registered or specialist nurse shall take necessary action to the best of his or her ability. And this is so appropriate for our hinterland regions, where there are times when you wouldn't even find a health worker, in the village because she has gone to look after somebody miles away. Mr. Speaker, in closing, I wish to commend all who have worked to bring the bill to the level it currently stands. Clearly, lots of work were done. But ask that the proposed changes I have made, especially related to our hinterland and its representation, be allowed at some time in the future. Mr. Speaker, I wish in closing to thank our medical workers for the sacrifices that they have made and the care they have given us, our children, and especially during the COVID pandemic. And we say a great thank you. And God bless you. And we know that when APNU AFC is back in the government seat, you shall be getting your just rewards. Thank you very much.
Thank you, Honorable Member Mr. Henry. The Honorable Member Dr. Vishwa Mahadio will now make a presentation.
Thank you, Mr. Speaker. Mr. Speaker, it is a privilege for me to speak on this bill, and I want to say at the outset that I fully support this bill and I endorse it. Mr. Speaker, I'd like to start by, before I make any comments on the bill proper, to just refer to some of the comments that were made by speakers before me. I want to remind Honorable Don Hastings that the Constitution caters for proroguing of Parliament. It also caters that when a no confidence motion is passed, legally, that 3 months after, they should vacate their seats, whoever is voted against, like the Honorable Attorney General would have mentioned. I'd also like to advise the Honorable Member to pay attention to the news as to what the President and what the government has been doing for the hinterland communities. And up to recently, there were statements that were made that would benefit the hinterland communities. Mr. Speaker, I see no problem with having a representative from health sciences instead, and I think Honorable Dr. Westford spoke about it, instead of naming the director. The director could also be the representative. It is for health sciences to determine. And I would also like to join with my colleagues, Dr. Westford and the others, in extending congratulations to our nurses. Last week was International Nurses Day, Nurses Week. And I'd like us all to congratulate them on the hard work that they're doing and thank them. Thank them in particular because these last couple of years, they have not been easy. With COVID, they still had to do their work. They still had to give the other vaccines. And then COVID vaccine came on board, and they continue to do their work. And I think, Mr. Speaker, they deserve our respect, they deserve our applause, and they deserve accolades. Mr. Speaker, I move on to the next speaker, Ms. Honorable Cox. And we know that, and I was shocked, Mr. Speaker, when the Honorable Member said that the Linden School of Nursing is closed. And so were the persons from the training division, and so they sent me something, and I'd like to read it, Mr. Speaker. Currently, at the Linden, the School of Nursing in Linden. They have 71 professional nurses, 18 nursing assistants, 3 post-basic midwifery, and medics 15 for a total of 107 students. Batch number 64, 24 students, batch 65, 27 students, batch 66, 20, nursing assistant class 17, 18. So, Mr. Speaker, I don't know where members from the opposite side are getting their alternate facts from. This was just sent to me. I don't want to use the word mischief, Mr. Speaker, but nothing better comes to mind. Mr. Speaker, the honorable member referred to the Honorable Attorney General making comments that it was a political campaign speech. But Mr. Speaker, all I have to say to that is that the truth hurts. And mentioning about poor health services in the hinterland, Mr. Speaker, over the last couple of years, in Region 1, 54 community health workers were trained right in the region. And for the first time, they have community health workers in Kukrit, in Chinese Landing, in Poikuru, in St. Asselin, in Barsina, and in Batero. Mr. Speaker, currently, as we speak, for the first time ever, nursing assistant training is going on in Region 1, where 25 students are in the current nursing assistant program right in Region 1, 21 from Region 1 and 4 from Region 8. Mr. Speaker, Region 9, and we had an honorable member from Region 9, 62 community health workers were trained, and for the first time, they are having community health workers in Kwaiko and in Kokshibai. So from that batch, they are having community health workers. And currently, in Region 9, Mr. Speaker, for the first time again, nursing assistant training is taking place right in Region 9, where there are 33 students in training, 29 from Region 9 and 4 from Region 8. So, Mr. Speaker, every single facility in these regions now have at least a community health worker. And I'll say further, Mr. Speaker, these health workers will be upgraded. They will be upgraded to provide more than community health worker basic services. They'll be upgraded to do things like diabetic foot care. They'll be upgraded, those of them who reach a standard to be able to do BIA, to identify early lesions in the cervix. Mr. Speaker, in addition to that, in these regions, we will be doing multiple lab technician training, and it will again be for the first time. I will also be doing pharmacy assistant training in these regions so that we'll be able to have adequate coverage in all the facilities. Currently, Mr. Speaker, we have with us a team from York University that is looking at the syllabus, at the curriculum, the nursing curriculum, so that we could bring it up to standard with the rest of the world, so that we could provide services, we could provide training comparable to the rest of the world. They are currently in Guyana. They'll be visiting all the training institutions, they'll be visiting the regions, and they will be making their recommendations. So, Mr. Speaker, things are happening, and it's happening quickly. Mr. Speaker, I'm tired of hearing installed government and people's voice will be heard. But Mr. Speaker, the people's voice were heard on March the 2nd, 2020. And this is why we are sitting on this side of the House and the honorable members are sitting over there. And Mr. Speaker, like they're saying, we're warming the seat, I distinctly remember when the no confidence was being debated, Mr. Speaker, the Honorable Attorney General is shaking his head. Those famous words, bring it on. Well, we brought it on, and you're over there. Mr. Speaker, the Nurses and Midwives Act was established in 53. Honorable Westford spoke about it, Dr. Westford. Amendments were made up to 1976. And it provided guidance, it provided some substance on the way at that time how things could happen and what was being done. Specifically, those acts dealt with practice and education for the public servant in Guyana. Like the Honorable Dr. Westford said, now we are having private nursing schools. Now we are having training from bedside nursing. We are having nurses in specialized areas. We have ENT nurses. We have ophthalmology nurses. We have emergency trained nurses. So we have different categories of nurses, Mr. Speaker. And so this bill caters to all of this. Mr. Speaker, I just want to also mention, talk a little bit about what the Honorable Attorney General mentioned. And again, I verified my facts, Mr. Speaker. From 2012 to 2015, work was being done on this very same bill. I spoke to Mr. Joe Hamilton, Honorable Member, and to the Council, who was a part of this. Consultations were done with the then Nursing Council, the Nurses Association, with PAHO, WHO, and others. It was then put together and sent to the Parliamentary Council for drafting of the legislation. And then, Mr. Speaker, 2015 came, and I'm hearing it wasn't seen. So, Mr. Speaker, this bill is a comprehensive bill. It speaks to the Council, and I don't see any reason why the Council, or how the Council could have the right to identify the salaries. Anybody could make recommendations as to what having salary increases, having better emoluments, better working conditions. And talking about working conditions, Mr. Speaker, working and not having things to work with, not having proper hospitals, not having proper health facilities, that's a torture. What this government would have done, by the end of this year, every single health facility, from hospital to health hut, inclusive of health centers and polyclinics, will have been upgraded, will have been fixed, will have been touched. So, Mr. Speaker, that's a caring government for you, and that is providing better working space, better working conditions for our health staff. Mr. Speaker, this bill clearly states what the Council should do: enroll, register, certify, and license nursing personnel. I asked a senior nurse, someone who passed through the system and who would have lived life as a health worker, from a nurse aide right up to doing a doctorate in nursing. And Mr. Speaker, these were some of the comments. Number one, all nurses and midwives who have been successfully trained and meet the registration requirement will be enrolled and licensed to practice by the Council without delay. And Mr. Speaker, it will be published, it will be gazetted, all those who are legally licensed to practice. Mr. Speaker, this bill also refers to continuing medical education. We are living in a fast-paced world. We are living in a world where today, every day, you have changes, you have developments, you have new things happening in medicine, you have new drugs, you have new methods, you have new equipment. And so, Mr. Speaker, this bill mandates that there will be continuing medical education for nurses. So our nurses will be up to date with what is happening in the world, and in that way we will ensure that our patients will receive up-to-date care from our nurses. Mr. Speaker, she mentioned that this year, for the first time, there was no exam fee. That's not included in the bill, but she just mentioned that, and that's a positive. Representatives on the Nursing Council, all areas will be covered. Mr. Speaker, I still do. This is why you asked me for help. Mr. Speaker, the Chief Nursing Officer will be ex officio. Health Sciences Education will have Director of Nursing Services of the Georgetown Public Hospital, representative from the nursing program at the University of Guyana, from the Nurses Association, representative, from the Midwives Association, there will be a representative, 4 members nominated by the Chief Nursing Officer, 2 registered nurses and 2 nursing assistants, a representative of the faculty of a private nursing school, a representative of the School of Nursing, 1 midwife, a technical officer from the ministry responsible for health, a legal representative, and a representative from civil society. Mr. Speaker, this covers all aspects of the society, having them have an input into the Nursing Council. Mr. Speaker, the nurse also mentioned that the bill covers the registration to ensure that people are properly qualified and that there are strict protocols to registration. And also, Mr. Speaker, the bill also speaks to persons being competent in our language, because we are having persons from other territories that where English is not their their native language, and so the bill also covers that. Also covers education, disciplinary and registration committees, which will be strengthened by this bill. Important areas of the nursing body that needs to be mentioned will be covered to maintain professional standards. Mr. Speaker, in this bill, there's also clauses that take care of to monitor the compliance of nursing educational institutions to educational standards set by the council. So, Mr. Speaker, this is coming from a practicing nurse who has worked through the system. It is a bill, Mr. Speaker, that is necessary at this time. It is a bill that can only see nursing in Guyana move forward. So, Mr. Speaker, I once again congratulate the Honorable Minister of Health and would recommend this bill to this House. Thank you.
Thank you, Honorable Member. The Honorable Member, Dr. Karen Cummings, can make your contribution.
Thank you, Mr. Speaker. Good afternoon, everyone. Just before I commence the speech on Nurses and Midwives Bill, I just want to allay the affairs of the Attorney General and the last speaker, Dr. Madio, that during the elections of 2020, prior to that, the no confidence motion, there were 3 processes. There was the political situation, there was the electoral process, and there was the political process. And so I sat there as a former Foreign Affairs Minister in 2019, and I thought I just want to set the record straight, to read into the Ansard. The government of Guyana, since the passage of the no confidence motion in the National Assembly on the 21st of December, we challenged its validity. The legal processes initiated were neither frivolous nor calculated to delay the consequences of the no confidence vote. And so they sought to explain more clearly and to interpret certain provisions of the Constitution. And so the court, as you know, it went to the different tiers of the court. And so the court declared that the provision of the Constitution at Articles 106, 6, and 7 applied to a no confidence motion, and that the government member of parliament who voted to support the opposition motion was ineligible to be elected to the assembly by virtue of its citizenship of another state, but that his vote on the motion of no confidence was valid. So you know that. And so that was the political situation in Guyana. And then we had the electoral processor. The CCJ ruled that the process applied to appoint the chairman of the Elections Commission was flawed, void, and in breach of the Constitution. And the government of the day, in accordance with the court's ruling, accepted the resignation of the chairman. The president embarked on a process to engage the leader of the opposition to select a new, and knew the history. And so the electoral process, you would have known. So there was a political situation, there was electoral process. And so the government of Guyana was keen to have elections in the shortest possible time. It had to be satisfied, however, that the basis for the holding of free, fair, and credible elections existed. And so the government of Guyana continued to uphold the Constitution and comply with the orders of the court. And so that was the electoral process. And then finally, you had the political process. The government of Guyana accepted that it was an interim government, and it continued to provide public service. The show had to continue. And so the Constitution at Article 106.7 states that notwithstanding its defeat in the National Assembly, the government shall remain in office and shall hold an election. The government has made it clear that during the interim period, it will restrain the exercise of its legal authority and prepare for the holding of general and regional elections by the Election Commission, which we did. We had to wait on GCOM to give us the green light. And as soon as we got that green light, immediately we went into motion. And so I just want to conclude this part by saying that the government of Guyana was committed to upholding the Constitution, respecting the institutions of the state, including the National Assembly and the courts, ensuring the rule of law, safeguarding human and civil rights, and preserving our democracy, especially through the conduct of free, fair, and credible local and general and regional elections. The Elections Commission had yet to inform the of dates, which I alluded to earlier, and which we did. And so we abide by the Constitution. So I just want that for the records. Mr. Speaker, I rise to speak on Bill 2022, Bill number 6 of 2022, which was published on April 8, 2022, and is under consideration and is now being read for the second time. This bill indeed is coming 12 days after the International Day of the Midwife and 5 days after the International Nurses Day. And so we salute our nurses. The Nurses and Midwife Bill was brought to this August Assembly on October 23, 2018, Bill number 13 of 2018. And had become an act following the assent to the then bill by the former president of the Cooperative Republic of Guyana, the retired Brigadier David Arthur Granger, on January 23, 2019, when he assented to the bill. But, Mr. Speaker, if there is any veracity in the statement that an act should not be repealed until the current one is passed, then how can this bill be repealed if, according to the members of this People's Progressive Party with a small civic component, it was not duly passed? Mr. Speaker, this bill, which is aimed to reform, to improve and to reform the nursing program in Guyana, and at a time where the world is facing a global shortage of 900,000 midwives, it was rather pathetic that on 2018, that day when we had a debate, of course, the former minister, Honorable Valda Lawrence, led the debate, and I myself supported her as the minister within the Ministry of Public Health at the time. And so it was really pathetic that the members of the opposition were, had been absent. And so it just goes to show how much they care, this compassionate and caring government that they claim to have. And so, Mr. Speaker, we know nurses and midwives play an integral role in the primary healthcare systems, in terms of antenatal care, intrapartum care, postnatal care. And so they have play a vital role in the health and well-being of women, children, and adolescents. And according to UNFPA, if governments invest in midwives, 4.3 million lives could be saved every year by 2035, thus reducing maternal mortality, neonatal mortality, and even stillbirths. Mr. Speaker, what I'm saying, I noticed the Minister of Health, maybe he has recused himself. Mr. Speaker, what I'm saying is that this bill, number 6 of 2022, is the APNU AFC's coalition's bill, and that from our mind maybe would have doctored, or rather I should use words that are parliamentary, like adjusted, and maybe it would have reworked and modified. And so here we have this bill number 6 of 2022, the current bill. Mr. Speaker, we on this side of the House, permit me at the onset to say, quoting after a religious leader, we on this side of the divide believe that the only thing that is constant is change, as it allows us to think and act in new and innovative ways. We firmly believe also that change should not be introduced for the sake of change, but because it ensures a better path to the future of our nurses and midwives. The Midwives Act, established in 1953, had sought to provide a framework for the regulation of nurses and midwives, education, principles, and practice. Of course, we know knowledge is power and knowledge is progressive, and it's evolving. You have new training. And so from that time, 1953 to now, there's been an increase in specialized nurses, in auxiliary nursing personnel. Nurses now have extended roles in mental health, in anesthesia, was alluded to earlier, in pediatrics, in neonatal resuscitation, in chemotherapy, in dialysis, ENT and ophthalmology, and even in non-communicable diseases, of course, which continue to take up approximately 70% of our health budget, and does have a public health significance. So may I inform you, Mr. Speaker, that they are now registered specialist nurses. What the APNU AFC sought to do was to have new and improved governing body to provide oversight to nursing in Guyana in a transparent manner, thus allowing for accountability and proper governance to this profession, as the accounts of their council could be now audited on an annual basis. Such corporate body would be responsible for the enrollment, registration, licensing, and the regulation of nursing personnel in Guyana, and to determine the requirements necessary to be satisfied for training as a nursing personnel. The development of code of ethics, the monitoring of compliance of nursing educational institutions to educational standards set by the council, as well as the exercise of disciplinary control via the imposition of fines to persons who have enrolled as nursing personnel and who would be tasked to govern members of this noble profession. It has been pointed out in this bill, like Bill 13 of 2018, that provision has been made for penalties to be imposed as deemed necessary, as in the case of a professional misconduct, or in the case of registration being procured falsely, or if there would be any fraudulent misrepresentation. In addition, Mr. Speaker, for the effective and efficient execution of duties of the Council, several committees, including education, standards, disciplinary, registration, and finance committees, would be established under the new bill. Mr. Speaker, let me just turn my attention to just a few of the points that raised, because I know my other colleagues would have spoken before, and I don't want it to be redundant. But just look at part 2, under clause 3, page 7, speaking about the establishment of the council. The implications for the function of the council as an autonomous body. But currently, Mr. Speaker, there is no council. The minister said that probably he's waiting the bill before the establishment of a council. So that's the implication for the function of the council. But what's the implication for the profession of nursing? What is the implications for the profession of nursing? The main function of the council is to regulate nursing, education, and practice. This includes tasks such as establishment of standards, which I alluded to earlier, nursing education, including licensing exams for nurses, prospective students, ensure that nursing practice the established code of ethics and so forth. So there are implications for the profession of nursing, and there are implications for nurses themselves. Absence of a council means there is no licensing body. Student nurses cannot be indexed. Nurses who are seeking their transcript cannot access this document. Students who wrote in May 2022 earlier, their state finals exam cannot be licensed. And so there are implications for nurses. There are implications for nursing care. Acts that require disciplinary actions of nurses, maybe due to malpractice, as I said before, cannot be meted out since there is no council to address this. And implications for the customer, patients, and relatives. The lives of consumers are at stake without a regulatory body. We're going to make, the recommendation is that install the council with immediate effect. The council was in effect since in the 1950s. The nursing profession needs to be guided by its own body and not necessarily by the Ministry of Health, since this leadership can change. Part 2, nurses looking to continue the function of the council. As I said before, under subclause A and B, speaks about enrolling and the registration and certification and so on, establishing the standards of education and so on. Implications for function of the council as an autonomous body. As I mentioned before, currently the schools have been established. There was no council in place to index, enroll, and register these students, ensuring students have the entry requirements for nursing, nor recommending a waiver of this requirement. And if this was a decision of the Ministry of Health through its health sciences unit, well, and so we see the implications for the profession of nursing. The role of the council, as I reiterate, has been relegated to some other authority now. This is contrary to what the bill is promoting. The question is, who registered these nurses and with what power? Since there was a need to open the school, then the installation of a council should have been given priority. Should any of these students find themselves in an unfortunate situation while performing tasks, since they were not indexed by a council, who will answer for them? So we have to be very careful. Functions of the council continue in clause 4. It's not included with the functions of the council. We saw that to conduct examinations for nursing and midwifery registration is not included. In the absence of the functioning council, the ministry has established an examination committee through its health sciences division to administer state licensing examination. We have to realize this is not a fly-by-night thing. This council was there time immemorial. And so according to the National Council of Nurses, which Guyana is a member, the International Council Confederation of Midwives, so you have the ICN, the ICM. Guyana also is a member of the Caribbean Regional Nursing Body, the RNB. It's only a licensing agency. So there are different tiers, and so it's not that you're moving out of council, because they already have assigned themselves to the RNB and also to the ICN and the ICM. And so council must conduct licensing examinations for nurses and midwives. And this prevents other agencies from conducting a licensing examination. The standard is set for the nursing by the International Council of Nurses. So you can't do your own thing. Let me have a few people from the health sciences and just set this exam. It's already established. There's a chain of command, so to speak. Implications. We are sure that all will not be well when the establishment of a state examination body be present to conduct the licensing examination. if it's viewed in the eyes of the international body, since the nursing is regulated as a profession by the International Council of Nurses. And so the International Confederation of Midwives and the Caribbean Regional Nursing Body, from which the Guyana Nursing Council takes a direction. And so this is already established. So the minister and they could be advisory, of course, they can, share their advice, but it's already established and it's working, so why change? Having a non-licensing examination is not good for nurses in Guyana. So you can't have an examination and not coming through the nursing body. The council monitors licensed nurses and midwives according to the Nursing Code of Ethics. And so we recommended that in this to conduct state examinations for nursing midwives, that the council do that, since they are the one to issue a licensing certificate on successful completion of such an examination. Nurses are assured of a licensing examination and a licensing certificate. This bill makes provision for several committees, as I alluded to earlier, including an examination committee that should comprise a senior specialist nursing personnel responsible for the application of examinations. According to ICN, this function cannot be transferred to a non-licensing body. Section Clause 5, page 7, powers of the council. The 2019 bill stated established standards of education, training, conduct, and performance for nursing personnel need to be done to ensure maintenance of these standards. So this follows the argument that a regulated body, according to the International Council of Midwives, that's the agency responsible for stabilizing, or establishing, I should say, standards for the training in nursing and midwifery. And so the recommendation would be this new bill should include under Section 2 powers of the council after item subclause B on the established standards of education and training, conduct and performance for nursing personnel, and to ensure the maintenance of standards. Page 9, clause 9, tenure of council. Like my partner, my colleague, MP Vincent, I think the tenure of the council should be 2 years, and that's the voice of the council. They think that 2 years is sufficient, and it's in keeping with Jamaica rule as well. And so to prevent a repeat of the current situation in Guyana, where there is no functioning nursing council, the Act should make allowance for some measure to be in place to ensure continuation of the functions of a council. And so you can do that either by the extension of the service by the previous council members or the election of an interim council, all right? And as I said before, an act should not be repealed until the current one is passed. We go to the last clause I'm going to deal with, miscellaneous, clause 48, under employment. The statement should read and include the word nursing. You just said, let me read it exactly, page 48, it's there. All right, but it should include nursing is omitted. We want nursing to be included. And so this helps to safeguard the position of the registrar, okay? Page 27, in the absence of the government subvention, the council has mainly relied on monies incurred from examination fees to pay its staff and to carry out its regulatory and other functions. So if there is no money, you really, I don't know what's the purpose of the finance committee. So you really want to make it either defunct because they're lacking the capacity to take away the powers from them. So how will they function? Is that deliberate, something deliberate, or you want to include in the multiple of council there's wisdom? And so now with a non-licensing committee administrating the state licensing exams, students are not required to pay. This grossly impacts negatively on the income of the council. How else will the council get funds to sustain itself? Is this an attempt to stymie the disannul the council? Come on, be frank. Although this is the previous act to have a subvention for the function of the council, a decision by Parliament is needed to enact this aspect of the bill. And finally, on the regulation, under Part 6, sub clause C, D, and G, what we're recommending, that under C we delete as a function of the minister. The minister has its place, but as an advisory role. The following tasks conferred on the minister, as already stated on the functions of the council, therefore they should not be given as roles of the Minister of Health. All right, regulating the conditions of practice of nursing in Guyana, well, the minister is going to do that. This is squarely the function of the council and should be deleted. D, subclause D, determining the professional qualification and experience required. All right, that should be deleted. And G, establish and enforce standards of practice. That should be deleted and squarely a function of the council. So we don't really want the minister to be usurping the functions of the council. We don't think it augurs well for the relationship of the two parties. And so the council have been doing a good job all the time, and we will want them to continue that. And so let's have some harmony with the council, with the minister. Mr. Speaker, no longer should nurses be seen as only administering vaccines at maternal and child health clinics and attend to the elderly and persons across life cycles. But this category of health professionals would now be positioned to demonstrate practice-based competencies. So, while the traditional bedside nursing can be worth emulating, as such a role is critical and essential to quality patient care, we do look forward to a paradigm shift with the nursing approach, as nurses are now asked to develop leadership roles and become transitional leaders in research, in education, technology, hospital management, and global health. Mr. Speaker, because of the nurses and midwives being able to have a valid license under the Registration and Licensing Act, there would be opportunities via the Caribbean Single Market and Economy, CSME, for the free movement of our Guyanese personnel desirous of seeking jobs in a CARICOM state. It would be expected that, like a snowball effect, trained nurses would teach patients and develop that nurse-patient relationship, which would inform their families about the natural history of disease and its treatment, and will commit to best practices and public patient safety. The Nurses and Midwives Bill 2022 has provided for continuing nursing education for this category of healthcare workers to understand holistic wellness, to attest to the needs of the healthcare recipients, to promote collaboration among the healthcare team, to manage well the resources of the health facilities and institutions, and to work with stakeholders in the community and society to have healthy people and healthy communities, the public health mantra. The bottom line, Mr. Speaker, is that this bill, number 6 of 2022, would help persons in the nursing professions, namely the nurses and midwives, to save more lives, to enjoy a better quality of nursing, to uphold the standards of professional conduct, and to promote a more effective and efficient management of nursing and the medical profession in a modern and oil-rich Guyana. Today, we want the nurses and midwives to know that the APNU AFC coalition, members of this side of the House, we're very compassionate and we care about you and your well-being. And so we would appreciate if the Nurses and Midwives Bill will be sent to a special select committee to fine-tune the anomalies created by the current PPPC regime. We, the APNU AFC coalition, would have pioneered this bill, and so we look forward to the PPPC making the necessary adjustments. It's the same, so that the persons considering entering this noble profession would be pleased. I thank you.
Thank you very much, Honorable Member Dr. Cummings. I now call on the Honorable Member, Ms. Halley, to make her contribution.
Thank you, Mr. Speaker. Mr. Speaker, as I rise to add my voice to this debate, I must place the bill before us into context. Mr. Speaker, it was, I think as was said before, in 1983 that the Nurses and Midwives Act was established and amendments were made in 1966 and 1976. And after 42 years, Mr. Speaker, with all that has changed in the medical field and the technological and other advances in nursing, it was not until 2018 under the APNU AFC and the then Minister of Public Health, Honorable Valda Lawrence, that it was seen as necessary to make further amendments and bring the Nurses and Midwives Act on par with the rest of the world. Mr. Speaker, Honorable Valda Lawrence informed the House in 2019 that, and I quote, with support from our partner, the PAHO, a legal consultant was appointed, and together with a team of key nursing leaders from both private and public sectors, and full participation of the executive of the Guyana Nursing Association, the bill was drafted and reviewed to ensure that it captured the pertinent issues in our nursing sector to ensure compliance with global standards and simultaneously ensure that it reflected our local cultural settings, and end of quote. Mr. Speaker, this bill became law in 2019. But since the PPP took office, they have decided to pretend as though the law does not exist because they believe it was illegal. I get it, Mr. Speaker. The PPP has chosen to go the political route, that all the bills that became law after December 2018 are illegal. While I wholeheartedly disagree with this notion, I still believe it is their right to believe whatever they choose to. The Honorable Attorney General spent much of his time trying to convince himself and his colleagues that the Nurses and Midwives Act of 2019 is illegal. But what I believe the attorney realizes, but is unable to publicly admit, is that the legality of a bill or act is not determined by the PPP, no matter how good he may find his argument. Only the court can determine the legality of a bill passed in Parliament and assented to by then President Granger. And as far as I'm aware, the court has not been asked, nor has there been any decision by the court on this matter. I believe that the Honorable Attorney General knows that. One, he knows that it was competently and properly passed, and that is why its legal validity can only be terminated by an act of repealing, which we can find in Section 52 of the bill before us. What I have an enormous problem with, Mr. Speaker, is that while this 2022 Nurses and Midwives Bill is before this House, the question begs, what is happening with all of the authority that the 2019 Act gave to the Council? Who has taken up that authority? The life of the Council ended in 2021. Who approved and marked the examinations of the nursing students? In the regulation of the Nursing Council, there are standards for the establishment of nursing schools. In the absence of a council, what agency authorized the establishment of a new school? I have been advised, Mr. Speaker, that the Ministry of Health, through the Health Science Department, established their own examination committee, issued forms to students to write the exams, and keep telling the nursing students they will be licensed at some point in the future. Is this what we have gone to? There are nursing students in each government nursing school which were indexed by the General Nursing Council. That is deemed illegal according to the Honorable Attorney General. Are the government nursing schools that are supervised by the Ministry of Health now illegal since they were utilizing the 2019 Act? In relegating the bill to an illegal status, I hope the Honorable Minister can spend some time informing all the nurses, midwives, specialist nurses, and nursing assistants trained in Guyana who wrote the General Nursing Council exam after 2019 and received license from that organization that he deems illegal, whether those persons are practicing with no valid license. You see, Mr. Speaker, the Minister of Health and the PPP have created a myriad of issues for themselves in trying to actualize a political stance that makes no sense logically or legally. I write it for myself, I can think. You see, Mr. Speaker, this is where we are. The education, examination, and licensing of our nurses and midwives have been in limbo for the past 5 months because of politics. So now we turn to the Nurses and Midwives Bill of 2022. When comparing to the 2019 Nurses and Midwives Act, with the version before us today for debate, there are some fundamental changes being made to the 2019 Act that would concern anyone who is interested in building and expanding the nurse fraternity and ensuring that proper systems are in place. The decision by the Minister of Health to come to Parliament with these amendments that quite frankly goes against the best practices followed by our CARICOM brothers and sisters and even further afield is quite disheartening. Mr. Speaker, we celebrated our nurses last week and there were many accolades going around, but if you were to ask any nurse, especially in the public sector, whether they feel valued, appreciated, or if their grievances are heard and acted upon, the answer would be a resounding no. The fact is, Mr. Speaker, our nurses are leaving in droves. Over the last 2 years, Guyana has lost 2/3 of the nurses trained in Guyana to migration, and nurses continue to leave. What the Minister and the Ministry of Health, what has the Minister and Ministry of Health done to keep nurses in Guyana? Where is the nursing strategy to retain nurses? Where are the brilliant minds that wrote these amendments? If we are to be honest, Mr. Speaker, most of the professionals in our public service are leaving. And I can guarantee, Mr. Speaker, that if this bill is implemented in its current form, this would further reduce the confidence of nurses in the system under which they have to function. What is striking, however, is the part of the 2019 Act that the Honourable Minister chose to omit in the bill before us. These omissions leave way too many questions. They leave way too many questions that the Minister has so far not answered. I know he's not here and the Attorney General seems not to have read the bill. Way too many questions. And I'm hoping that by the end, after all that my colleagues have said, he would have some answers to us as he closed the debate. Mr. Speaker, in Part 2, Section 5, Sections A, H, and I, subsections A, H, and I of the 2019 Act were omitted from the bill before us. I would like to focus a little on subsection H, which states that the Council shall have power to determine the programs of training and the curricula of study to be followed in the training of nursing personnel. If the Minister of Health has decided that the Nurses and Midwives Council should no longer oversee the programs of training and the curricula of study to be followed in the training of nursing personnel, who will? Which agency or organization does the Minister intend to make responsible for this important task? This cannot and must not be taken flippantly, and this grave omission must be rectified. A regulated body, according to the ICM, is the agency that should be responsible for establishing the standards for the training in nursery and midwifery. The examinations taken by our nurses cannot be seen as another school-based exam, but rather a licensing exam which must be done by a licensing agency. That's the medical rule. How do we ensure that the standards are maintained? Who will ensure that whether private or public, the curricula and exams are at a high standard? Mr. Speaker, in Section 9 of 2019, the Act states that a member shall hold office for a period of 3 years and shall be eligible for reappointment or re-election. However, this 2022 bill before us states that the members who are not ex officio shall hold office for a period of 3 years and shall not be eligible for reappointment or re-election. Mr. Speaker, the only ex officio member stated in this bill is the Chief Nursing Officer. This council is supposed to hold up these 15 persons. Mr. Speaker, anyone who has held office on any board or council would understand the importance of institutional memory and also be able to, and the need to retain someone who could help the organization to reach its goals and effectively fulfill its mandate. Why then would the state suggest that once you served on the council once, you cannot serve again? Who can gain from this? The PPP would be better off giving themselves term limits than attempting to limit the ability of persons to contribute to the Nursing and Midwives Council in a meaningful way. Further, Mr. Speaker, To prevent a repeat of the current situation in Guyana, where there is no functioning nursing council, the Act should make allowance for some measure to be in place to ensure continuation of the functions of a council, either by the extension of service by the previous council members or the elections of an interim council. Back in 2019, Mr. Speaker, we did the requisite consultations before we brought a bill before the House. The question now is, was any consultation done before the minister brought this bill to the House to be debated? Who exactly was consulted? Because based on what is before me and the conversations I have had, many persons are discouraged, concerned, and worried about how these changes would impact the nurses, nursing, midwifery, and all those who may have to engage. I am advised, Mr. Speaker, that a regional body in partnership with the Caribbean Nurses Association has registered its concern on a matter which was brought to their attention regarding this particular bill. And I quote, "It is a considered opinion of the regional nursing body that the nature of the concerns expressed violates the professionalism of nursing in Guyana by removing its autonomy to self-regulate, a vital criterion for the profession. Consequently, this could compromise standards of nursing, education, and practice within Guyana. Even more egregious is the potential negative impact on safety in nursing practice and patient care outcomes, given the globally recognized critical role of nurses in healthcare systems," end of quote. Mr. Speaker, the fact is that we needed a new bill. The old bill didn't work. In 2019, we brought a new bill that became law. The PPP has chosen to pretend that bill and that act does not exist. Fine, it's their political right to so do. But if you're going to come to this House with a new act or a new bill, you have to ensure that you, one, do the consultations with those that will be affected and ensure that what you bring to this House is helpful and will carry whatever it is forward. The way I see it, Mr. Speaker, this bill leaves much to be required. The 2019 Act was of a higher quality because we consulted. The bill falls short of international best practices, which should be looked at before I think we should pass this in this House. So I would like to suggest that the Honorable Attorney General just take these that came from myself and my other colleagues under consideration before passing this bill. Thank you.
Thank you, Honorable Member, Ms. Tabitha Sarabo Hali, for your contribution to close the debate. Call on the Honorable Attorney General and Minister of Legal Affairs, Mohammed Anil Nandla.
Thank you, Mr. Speaker. Mr. Speaker, I spent great time and energy in my opening presentation to situate this bill in a particular context and to give the rationale for its promulgation here in the National Assembly. I made it clear also that the bill is reflective of the 2019 Act in almost every material respect, save and except some changes which were effected. I explained, Mr. Speaker, that the bill was unlawfully passed by a government that was defeated by a no-confidence motion and by a parliament that did not have the power under the law and the Constitution to pass that bill into law. And it was we lost the authority to assent to a bill to make it law. And all of that is a defeat of the APNU-AFC. In violation of the Constitution, in violation of the rule of law, they imposed a legislation on this nation by an ineffective parliament and by a government that lost the power to do so. Rather than, and we have a court ruling from the highest court in this land supporting that position. Rather than accept an error was made. Or rather, better yet, accept that they acted unlawfully and they violated the Constitution. Every single member on that side spoke with great gusto, trying to justify and explain the flagrant and blatant illegality. And I am happy that they have done so, because every time this issue arises and they defy the Constitution once again, and they defy authoritative pronouncements from the court, and they defy the rule of law for the people of Guyana and the world to see, it helps us on this side politically and in every other way. Because it shows that after 28 years of rigging election, and they were given a chance in 2015 to 2020, nothing has changed. Nothing has changed. So I am happy, honorable members on that side, that once again you have given this nation this deep insight into your psyche and allowed the nation to see how you think and how you regard the Constitution and how you regard democracy. So, Mr. Speaker, this whole big sermon and presentation that we heard about a structure being set up under this act and what will happen now, you set up a country is governed by laws. You can't pass a law illegally, then set up an entire bureaucracy under that illegal law and expect a lawful government to accept it. It doesn't happen in the real world. It doesn't happen in the democratic world. So we had to dismantle that illegal, illicit, and unconstitutional structure that you have erected upon the bureaucracy of this country. And that is what we are doing today. Mr. Speaker, the other bizarre thing that I observed is that the Honorable Senior Minister at the time, the distinguished Valda Lawrence, takes ownership of the bill from her seat in very loud and decipherable grumble and assertions, and that has been adopted and echoed by every member who spoke on the bill. So the bill, in their speeches, is an APNU bill. It is their bill. Yet every single one of them held the bill up and beat the bill for a song. I don't understand. You take ownership, you say it is your bill. I have already said that we have made only minor changes. So yes, it is your bill, and each one of you proceeded to bore one hole after another in the very bill that you take ownership of. You are confusing not only me and us on this side, you are confusing even your own supporters and every single Guyanese in this country. That is why the honorable leader of the opposition the other day made this positive and bizarre assertion that he has the winning SOPs. It is the same vein of confusion. And when confronted to produce it, he says he never says that. He never said it. And then he jumps into a wrong vehicle again. The same level of confusion. It permeates every action of yours. But I am happy that it is happening because the people of our country, the people are witnessing, including your rational and very sensible supporters, a lot of which you have, I know. So I am glad that you are revealing this in this very graphic way. The honorable member, Miss Hastings, school teacher, I have the highest regard for the honorable member. She takes great objection for me describing their detention of the reins of government for 5 months as squatting. But that's an acceptable term when you are trespassing in a province where you have no authority to be. It is called squatting. So yes, you said, and the honorable member in response speaks about a no confidence motion that they tabled in 2014. And what did we do? The honorable member accuses us of proroguing the parliament. But that is what the Constitution permits us to do. You don't even know wrong from right, and that is my problem. We didn't stay in office, we didn't squat, we didn't refuse to hold elections, we prorogued the parliament, a constitutionally authorized process, and then we dissolved the parliament, and then we went to the elections, all of which are authorized by the Constitution. What you did in contrast, after your defeat, you refused to resign, you refused to hold an election within 3 months, you went back into parliament after the parliament would have been effectively dissolved, you pass a law, then you further squat for another 1.5 years in the parliament, and then after you lost the election, you squat for another 5 months in violation of the rule of law and the Constitution. You see the graphical difference? I hope you, well, I can't help you. Coletta, you're a teacher too, honorable member. I can't help you. I now have to really pity our school children. So I hope that I am illustrating in very clear and unambiguous language the differences in approach, what the law says and what the Constitution authorizes. So the honorable member Ronald Cox, I'm grateful for him identifying myself, my esteemed colleague, the bishop, and a few others on this side as senior politicians, I think, and I bow in acceptance. I'm humbled by the compliment that he has conferred upon us. But what the honorable member, he said to us that after the parliament, after the no confidence motion, we continue to receive salary. Now, under the Constitution, you are to remain in government for the purpose of carrying on the country for 3 months with limited executive power, as I have outlined in my opening remarks, and there is no need to reiterate that. And your responsibility over the fiscal affairs and public funds of the nation, however, continues. You were in charge of payment of public monies. That is a power that the Constitution confers upon you until you exit office. So once you remain there, you are in charge of the treasury, and you chose to pay all the parliamentarians. And if there was any wrongdoing there, if there was any fiscal responsibility there, then you must accept that fiscal responsibility. And then just juxtapose that for one moment with the case of Keith Scott and Winston Felix. Now, these are two distinguished members who were elected to the parliament after the 2011 elections and after the 2015 elections, and they were put to sit in the parliament. By 2016, the then Chief Justice of the country declared their election to the parliament and their holding seats in the parliament as null, void, and unconstitutional. Then they appealed, and they went to the Court of Appeal, and they got a stay of execution against that Chief Justice's pronouncement, and remained in office for 4 years. They sat in the parliament, and they received their money. Eventually, the case came up in the 5th year, after they would have received salaries for 5 full years. The case came up in the Court of Appeal, and the Court of Appeal confirmed that the Chief Justice was correct, and therefore they were sitting in the Parliament for 5 years, illegally and unconstitutionally. And guess what? They got paid for the 5 years. Where is Mr. Cox? Could you get them now to bring back the money, Mr. Cox? That is a clear case where a court has pronounced. So, Mr. Cox, when you give these examples, you have to understand. Now, let's come to you, Honorable Member. Vincent Henry.
Okay, Honorable Attorney General, you know, I'm going to have to punch a lot of holes in your presentation because all the yous refer to me. And I had the Honorable Deputy Speaker waving his hands because you're including him in the opposition too.
Oh, I'm
And he
sorry.
wasn't there.
I'm sorry.
So let's get back on track.
Yes, please, Your Honor. So, the Honorable Vincent Henry, I don't know which bill he spoke on. I don't know which bill. I'm sorry. I'm sorry I'm unable to respond to you. I didn't understand much of what you said. And what you said really had very little relevance to the bill. But, Mr. Speaker, what I recall distinctly emanating from the lips of everyone who spoke on that side was this love and affection and glowing embrace for our nurses. Every one of them expressed this great affection and love and natural affection for our nurses. But you know, not one of them, and especially during the COVID pandemic, all of them highlighted and saluted the role of our nurses. But you know, not a single extra cent did they pay to our nurses for those heroic role that they played in the pandemic. Unfortunately, or not unfortunately, in contrast, the PPP Civic not only loves the nurses, but we paid in 2020 and in 2021 COVID grants to the health sector workers right across the length and breadth of our country. So we don't pay lip service to the love. We don't pay lip service to the affection. We deliver in dollars as well. And that is what we have done. And that is the difference between the two sides. So, Mr. Speaker, a lot have been said about what will happen with the new structure. Well, once the bill is assented to, and the bill is lawfully passed, and you have a president authorized in office to assent to the bill, the structure will be established in accordance with the bill. Huge moment was made of clause 53 of the bill, and all clause 53 does is to speak to a transitionary period. That, you know, the council that is there will continue to be there until a new council is elected. And all kind of fancy languages and enunciations and pronunciations I heard from Dr. Cummings. Very sophisticated. She was attempting, the honorable member was attempting to justify what transpired during that period after the no confidence motion, explaining to us about governmental processes and electoral processes and processes in government. And oh my God, you can't fault the honorable members for, you can't fault them for alleged sophistication. That is intact. What, my God, substance is missing. Substance is desperately missing. So, honorable members, I thank you very much. This is a very important piece of legislation. It originated from our side. I think all of you would seriously accept that, but you did play a role in perhaps fine-tuning it. Unfortunately, in the heat of your unconstitutional pursuit, you blundered severely and got it into the parliament after your government would have been defeated. And that's a terrible tarnish on your reputation. We are trying to rectify that, and I assume that we have your full support. Thank you very much, Mr. Speaker.
Thank you very much, Honorable Attorney General. And I will just ask the clerk to make note of the editing that we have to do with respect to the opposition, deleting the honorable member, deputy speaker, and where you had been profusely used Let us put the bracket afternoon AFC honorable members. Honorable members, I now put a question that the bill be read a second time. Those in favor say aye.
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 Those against say no. Ayes have it. Let the bill be read a second time.
The Nurses and Midwives Bill 2022, Bill number 6 of 2022.
The House will now resolve itself into committee to consider the clauses of the bill. Honorable members, I see no amendments tabled, and so I will propose the question that clauses 1 to 53 form part of the bill. Honorable members, I now put a question that clauses 1 to 53 now form part of the bill. Those in favor say aye.
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 Those against say no. Ayes have it. The clauses 1 to 53 now stands part of the bill. Honorable members, I now put a question that the bill be reported to the Assembly. Those in favor say aye.
Aye. Aye.
Those against say no. Ayes have it. Let the Assembly resume. Honorable Attorney General and Minister of Legal Affairs.
Mr. Speaker, I rise to request that the bill be read a third time.
That the bill was considered and passed as printed.
And that's the bill was considered by clause in committee and passed as presented. And I therefore respectfully request that it be read a third time. Thank you.
Thank you. The question is that the bill be read a third time. Those in favor say aye. Those against say no. Ayes have it. Let the bill be read a third time.
The Nurses and Midwives Bill 2022, Bill number 6 of 2022.
Thank you, honorable members. This is a good time to take the suspension.